Hello, everyone. It is a Monday. It is 2023, and things have been interesting lately. We all agree. Oh, wait, I have to turn on the captions. Yay, now we have captions running, and why did Pretzel just fail? Pretzel, why fail? Why fail Pretzel? Why fail? There we go. There we go. There we go. Got some chill tunes going. We feeling pretty good about life. How are you all? I'm your friendly neighborhood Prax. Welcome to the channel. It has been... Hello, Baron Tor. Welcome in. So we're going to chat tonight. We're going to chat... Wow. Wow. The OGL 1.1 is trending with 7.5 thousand tweets. Yo. And you know that the trending only goes in like the last hour? So that tells you a proportionality of the number of tweets. Just saying. Just saying. So, yeah, I managed to get a hold of, of a copy of the leaked document of the OGL 1.1. Now, I'm going to preface this with 3 statements. Statement number 1, we are going to have fun, and we're going to be polite, and we're going to talk nicely to each other and not be assholes. That is statement number 1. Statement number 2. Where is it? There we go. I have to turn on a thing. There we go. There we go. So that thing is turned on. I am not yet officially a lawyer. I am a 3L law student who has a specialization and concentration in intellectual property law. I spent a lot of time reading trademark, trade dress, copyright, patents, all of the above, right? Spend a lot of time with IP. I am officially a legal intern, which means that I can sign a document in court and submit that, but I am not yet officially a lawyer. I have not passed the bar anywhere. I have not been accepted as a lawyer in any official state in the United States. I am, however, very good at doing research and very, very good at having a subject matter expertise in writing this. Okay. That is caveat number 1.5. Be good and polite. Number 2, not yet a lawyer, but I will be soon. And number 3, the document we are going to be talking about is number 1, a leaked document, and number 2, not the final version. So, anything I say about this document, take it with the caveat that this is not the final version. Everything can change. And do not do anything without having a lawyer look at it first. Hi. Welcome to the channel. This is where Prax is going to chat law. It'll be fun. Malkadoshian says, at what point can I start running around my room, flailing my arms around wildly and panicking uncontrollably? I mean, you can do that in your own space without engaging anyone else at any point if you desire. I will never stop somebody else from panicking if they so desire. But don't bring that stuff on Twitter and don't bring that stuff in here, because we're going to say a lot of things. I have my opinions about the document that I have read, and I did read it. I read the whole thing. Hello, Sly. Welcome in. I have opinions about the document as I have read it. I have opinions about, things, but we're not going to attack any of the people at Wizards because this document comes from Hasbro. We're not going to attack any of the actual plebs at Hasbro because this is coming from a much higher position than anyone else. Look. Panicked screaming into a pillow by yourself is always acceptable. But if you scream next to me, I'm going to assume that one of three, I was a teacher. If you're screaming next to me, as a teacher, I'm going to assume one of three things is happening. 1, you're on fire. 2, you have blood. And 3, somebody's trying to run away with you. If those are not one of those 3 options, then there's no reason to be screaming in my ear. Right? So, like, those are... Unless there is blood, fire, or kidnapping, there's no reason to be screaming in my ear. I wish more people would take that ideology on Twitter and social media in general, but... Also, next statement, number 1. This is an opinion based on legal study. Again, opinion based on legal study and an understanding of copyright, trademark, and trade dress law, and licensing law. This is not me defending Wizards of the Coast. This is not me fangirling for Wizards of the Coast. If you've hung out on this channel long enough, you know we do a lot of different games here, and there's only one TTRPG company that I fangirl for, and even then. So Sly is... welcome in, Scabbynack. So Sly, Wizards... again, this document we're going to be discussing is not released. It is not public. It was a leaked document. I want everybody to understand that, because I think a lot of people have been focusing on this in the wrong way, in a way that I think might be not good. But, you know, again, everything is subject to change. Exactly. Like, this is a leaked document. Again, this is subject to change, and as this is a leaked document that I got a hold of by third party, I'm going to say I can neither confirm nor deny if this is the actual document at any point, right? Like, I can work with what has been leaked and therefore people are talking about, but a leaked document with no provenance attached to it, it could be fake, it could be real, it could be a draft that somebody was putting together, it could be a lot of different things, but because this is what people are talking about, I want to talk about as it exists and what it means as it currently exists. This is not me defending Wizards of the Coast. This is not me defending Hasbro. This is not me coming for Wizards of the Coast. This is not me coming for Hasbro. This is me providing as much information as currently available to people in a calm and reasoned manner. Now, there have been a lot of other lawyers out there who have made comments. My lawyer friend, Noah Downs, his title on Twitch and Twitter is My Lawyer Friend. He's a very knowledgeable individual. He works a lot in video game law. He was one of the creators and founders of Pretzel Rocks, and he still not only works for them even after they sold the company. Very cool dude. He does a lot of work with Lost Ark. Had the pleasure of having a conversation with him before. He has a really good breakdown blog post about the document itself. Legal Kimchi also has another opinion, but as Legal Kimchi also pointed out, you can ask 5 lawyers about this document and you will get 8 opinions. Okay? Because, oh wait, I downloaded it and I didn't, poopies, poopies. I did the thing and I didn't do the thing. We'll have to fix it. Didn't I do the thing? I thought I... So, I'll do it later. But, apparently it didn't work. That button didn't work. I'll figure out why it didn't. Because the wonderful, fabulous... The point is, you'll ask 5 lawyers and you'll get 8 different opinions, because in the law, the statement, "it depends," is very important. Because the law in the United States, Canada, and but most English-speaking countries, is very fact-dependent, right? Like, I was trying to keep it PG so that when it goes up on YouTube, I don't get dinged, but probably not gonna work. I put that mug away. I got a mug. It says, I have the vocabulary of a very well-educated sailor. True statement. But it depends is a very important statement for lawyers, because the law is each case is going to be very, very fact dependent. The law is based on case law, and while you can make comparisons, like this thing is very similar to this thing, if the individual facts might change the interpretation that the court allows for it. So, again, all of this will depend. None of this is set in stone. This document could very well be fake, because I wasn't given this by some random person, you know. It wasn't like somebody at Wizards of the Coast handed me this. No, I got this third hand from somebody else who got it from somebody else. I can't guarantee the provenance on it, but it's the document that people are talking about, so that's what we're going to talk about. It is a thing that is a thing, and therefore, okay. Would be very important to talk about. So, let's start by talking about what the OGL, the current, because I got into this on Twitter, and I tried really hard not to, but a couple people came after me, and I am a Sicilian, and I'm Sicilian and Irish. Look, I will try and be polite on Twitter because it is a public forum and nobody needs that shit, and I know not to feed the trolls, but if you come at me with bullshit that's false, I will respond with receipts. Don't at me. So why don't we start by looking at the document as the current OGL exists. So why don't we swoop into the thing? All right. So this document, I'll even make it bigger. This is the current OGL, the current document that people are writing on. Polite on Twitter seems to be a rarity. Look, I try. Because I recognize that there are other people on the other end of the internet and, you know, whatever, but D&D trending on Twitter with 3.2 million tweets right now. There you go. Thank you, Barontor. And again, this is January 9th, 2023. As of, it's 9 o'clock, effectively 9 o'clock at night on Eastern time zone, which is where I currently reside. So this is the current publicly available SRD and OGL. Now, 3 points to go back into with this document right here that we are talking about. I will even put the link to this document in the chat, and when this goes up on the YouTube, which by the way, I have a YouTube, you want to check it out, it's over there. And I've had a bunch of chats about a bunch of different D&D stuff recently. But when this goes up on YouTube, I will make sure to link to the document that I am talking about, both documents that I am talking about, so that they are easily available to others. So this document number 1, this is the official OGL and SRD. Wizards of the Coast created the OGL. The OGL only applies to Wizards of the Coast created documents and properties. Those independent gaming companies that copy and pasted this document as their OGL were not right to do so and should not have, because it's not what you do. You do not Just copy and paste somebody else's document. Legal contracts are not, unless they say that they are a form document or a boilerplate, do not ever go there. Oh, Unstable Dio says Wednesday evening on Extra Credits Twitch channel during the Extra Politics show, there will be discussion of this challenge, which will involve one of the people who helped write the OGL 1.0. Okay, so I have a very important question for you, Unstable Dios, and this is a very, 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 very important question. Is this individual who is involved in the writing of this, the OGL 1.0, a lawyer? Because if the answer is no, it doesn't mean anything. Right? Like, it does not mean anything, and we're going to explain why in a couple points. And I'm going to have to use some legal definitions and terminologies to explain some things for people, but if this individual is not a lawyer or has legal training of some sort, beyond just they read a lot of contracts because they're corporate, do not, it won't matter. So, why did that do that thing? Okay, things were going weird, I apologize. So, this document right here that we were talking about, this is the most important thing that we're going to consider for... Okay, see, that's the thing. Yeah, if you can get their name on Stable Dios, I would appreciate it. As Barantor says, Ryan Dancy was talking about how he thought it was a forever license and he helped write 1.0, but he's not a lawyer. So Ryan Dancy... Oh, it will be Ryan Dancy. Okay. Ryan Dancy is a lot of things, but he is not a lawyer and he's never been to law school. And this is going to get into some things that are very important terminology to understand why what Ryan Dancy is going to say isn't as important as what he thinks it is. Now, it's important because it gives an insight into his thought process with the creation of the document. However, what he thinks it did and what it actually did are not the same thing. And we're going to go through that. We're going to go through, like I had done on the YouTube, I had done a breakdown about what the OGL is and what it isn't and what it covers and what it doesn't. Remembering, of course, that the OGL and the DMs Guild are two different things, and 90% of what people are freaking out about in the new document also is part of the DMs Guild already. That's just a thing. But there are certain terms that are in this document that have very specific legal meaning that is not necessarily the same as its conventionally understood meaning in proper English, in non-legal English. So why don't we start with what this whole document is, right? So this whole document, the first 2 pages are the license, right? This is the official current existing license. This is 1.0 or 1.0A, right? Okay. This is the official Open Gaming license. This is a downloadable document. You can find it on their website. It is current legal binding license. I have not seen a release of anything else, so this is the license as it currently exists. Now, this material is being released using the Open Gaming License version 1.0A, and you should read and understand the terms of that license before using this material. Hi. Read the license, then use the material. So the material that they're talking about here is everything that's in the SRD. So this document is 398 pages long, only the first 2 of which are the license. The rest is the SRD. The SRD being the systems reference document that is used by people that you can just copy. That's the document in pieces that you can copy and paste into your D&D 5e based system game, or even 3e or 4e technically. Because, sort of. in a roundabout way. It gets a little fuzzy, but this is where we're going to go. So here's the point. This document release is the official document. The text of the Open Gaming license itself is not open game content, right? The license itself is copyrighted. So everyone who just copy and pasted the license and said now that this is also going to apply to our system and our material, they weren't supposed to do that. And they aren't technically, it's not, the Open Gaming license only applies to Wizards of the Coast material. And anyone else using it who isn't using Wizards of the Coast 5e material has a problem, because this document is only designed to cover and license, right? So we have to remember that at the core concept of here is a license. And a license is a type of contract whereby a person owns a thing, in this case an intellectual property, the game of Dungeons and Dragons, 5th edition. They have a thing. They own the thing. They can do whatever they want with the thing. A license means that they're turning to person over here and says, oh, you want to use my thing? Okay, I am allowing you to use my thing with these limitations. There is always a limitation on how you may use someone else's property, right? In a license for an intellectual property, it's going to be things about branding, how much of the property you're allowed to use, logos, specific terms, all of these things are going to be included in the license. Anyone who says they can just pick up and copy and paste the OGL and use it as for their independent game system, which has no Wizards content in it at all, is wrong. You do not look to Marvel. You would not be like, look, you as this third-party artist isn't going to look at a document that Marvel is using and say, oh, that means I can use DC's Batman, right? Like, Marvel cannot tell you you're allowed to use Batman. But those companies that decided that the OGL was a universal document like the Creative Commons decided to say, well, we like what this says, we're going to take this and we're going to use it to license our stuff. Even though the license only applies to Wizards. And a lot of people, particularly on Twitter, this one individual in particular who got into it with me on Twitter, and I had to bring receipts, it's fine, seem to be under the mistaken impression that this document is created in such a way that it will allow people to copy and paste and then it will apply to everything. It doesn't. And the problem is because people start reading this at here. Yeah, Barontor says, yes, Basic Fantasy is now in rapid erase SRD content and use the Creative Commons license switch. Yep. The problem is that people started here in this bottom of this first column in the statement that says Open Game License version 1.0A. And they forgot that there's a whole 3 paragraphs above that are real important. Because in a license, which is at its core a contract, and a contract is an agreement between 2 parties, you always have to define the terms and parties involved in the contract going forward. And if those terms and parties. Again, going back to our Marvel and DC, right? So I'm an artist and I pick up this contract that Marvel has handed me, and the person's defined, the people defined as being parties to the contract at the beginning of the contract are DC and not Marvel, then I don't have a contract with Marvel. And I can't do anything with Marvel. Only the parties that are named in the contract are parties to the agreement. Now, a lot of people are talking about Ryan Dancy and his comments that are on about using these and all of these things. And theoretically, this is where the most important point for Ryan is going to be a problem. He can say anything he wants about what he thought the gaming license was or what he wanted it to be. But if those thoughts and wants are contradicted by the words on the page, what he thought doesn't matter. In the law, particularly contract law, right? Because a contract is an agreement between two people, and language is difficult. Language is complicated. Different people have different meanings. One of the most basic contract cases we will, in introductory law school that you study, is about a contract for chickens. For a supplier, for a buyer and a seller, and the buyer had, they wanted X number of chickens. And the seller said, all right, I'm going to sell you X number of chickens. Well, the buyer thought he was getting, and this is a real case that went all the way to Supreme Court. Yes, it is a case we actually had to study. It is a very important case about language in a contract. The buyer wanted what is called, fryers, and the seller sold him roasters. Now, if you walk into a grocery store right now, you can pick up in the whole chicken section, there are chickens labeled fryers and there are chickens labeled roasters. This is about the size and age of the chicken at the time it died and which has to do with other things, right? And this isn't even about breeds. This is about the size of the chicken. And because the document only said chicken, and both parties could see, and they're priced differently, right? Fryers and roasters are priced differently. And that's why this is like a multi-million-dollar case based on adjusting for inflation and the number of years that this case happened to go. So this case, this buyer thought, hey, I'm getting a really good deal on these fryers. And he shows up with roasters. It's like, that's not what I ordered. Well, yes, it is. You said you wanted chickens. These are the chickens. The whole court case is based about the fact that there was no definition in the contract between what type of chicken the two parties were talking about. And because of that, the court ruled that the term is what is called ambiguous, right? If both parties could legitimately believe information based on things in the contract and words in the contract and have two different meanings or multiple meanings for the terms in the contract is what we call ambiguous. And therefore, you couldn't have what is called a meeting of the minds, which is where both parties know exactly what the other one is offering, and therefore both parties can agree to the terms of the contract. And therefore the contract is null and void. This is important. In every contract since, buyers or sellers or insurance, almost everybody in this chat has had to buy, if you were over the age of 18, you had to get insurance, right? In your apartment, on your car, health insurance, whatever. Your insurance document that you get is a contract. It is what the insurer, in this case, the insurance company, is offering to cover for you and what you are agreeing to pay for that coverage. every one of these contracts includes the definitions somewhere in the contract, so that people can't come back later and say, well, we thought that this term meant X and we thought that this term meant Y. Definitions are the most important part of any contract, and this is no fault. And again, so while Ryan Dancy may come back and say, well, I believed I could do this thing, if whatever he believes is contradicted by what we call the four corners of the document, the court is going to turn around and say, well, I don't care what you thought. You signed, this is the document you offered. This is the document that people are agreeing to. This is the document as it exists. This is what the court says. But see, Coldrake, we don't even get the party of the first part. We define those, right? We go back to, and this is why people skipping down to the bottom of this on the Open Game License version 1.0a, to the very bottom where it says, gives you the title, in skipping this part about saying the following items are designated product identity and are defined in section 1e of the Open Gaming License version 1.0a, and are subject to the conditions set forth in section 7 of the OGL and are not open content. Right? Like, the document itself is including definitions, right? This very first sentence here, all of this, these definitions are vitally important. If you are going to make an argument about a contract or a license or anything like that, and it is contradicted by the terms in the plain language of the contract, including terms that might be slightly ambiguous because they might have more than one meaning, well, you know what? Those contracts are going to have definitions, right? And those definitions are going to tell you exactly which meaning that contract is applying. So, it is important to consider that if you, as a gaming company, didn't change the definitions of the contract, then the contract didn't apply to you. If you didn't change the name of the parties, the contract didn't apply to you. So, we've talked about this contract a lot. We've talked about all of these things a lot. Again, there's a YouTube VOD up of us going through this the first time. I will make sure when this goes up on YouTube, I will add a card somewhere. It'll be there to link to those previous VODs. But product identity, the definitions can define contributor, the derivative material, which means copyrighted material, including derivative works and translations, including into computer languages, quotation, modification, correction, addition, extension, upgrade, improvement, compilation, abridgment, or other form in which the existing work may be recast, transformed, or adapted. How you may distribute it, what the open game content is. Product identity means product and product line names, logos, identifying marks, including trade dress, artifacts, creatures, characters, stories, storylines, plots, thematic elements, dialogue, incidents, language, artwork, symbols, designs, depictions, likenesses, formats, poses, concepts, themes, and photographic, and other visual or auditory representations, names and depictions of the characters, spells, enchantments, personalities, teams, personas, likenesses, and special abilities, places, locations, environments, creatures, equipment, magical or supernatural abilities or effects, logos, symbols. All of this is covered as part of the definition. And this is why legal documents have to be so specific. If what he says contradicts the four corners of the document, then it doesn't matter what he said. Now, if what he said, now this is a hypothetical, but if if Ryan Dancy, why did I call him Roger? If Ryan Dancy comes out and says, well, we were considering X, and X is not specifically discussed in the document, then certain states might consider what he was thinking at the time of the drafting of this document. Not all of them. Some of them. This is what is called parole evidence. Parole in this case means just literally from the French term spoken, as in not written down, things that were discussed. Most business contracts now usually include a clause or a term in the contract where this is the final and revised version of this contract. All previous versions of the contract or all discussions about the contents of the contract are incorporated or infused into this document, and therefore, and that clause is to specifically address what is the parole evidence. Parole evidence is evidence about a contract outside the four corners of the contract. It's very hard to get parole evidence admitted. Courts don't like it. But it is but it is possible to do if there is something that is ambiguous, or if there is discussing a concept that isn't specifically addressed in the contract. If, however, whatever he says is contradictory to terms specific in the license, then the parole evidence doesn't matter. It will never be admitted. No court in the country admits parole evidence if it contradicts the existing document. Because you can then say, well, this is what I thought and this is what I meant. You can say what you think and what you mean, but this is the contract you offered to the audience and to the world, and therefore you obviously must have changed your mind, is what the court will say. Like, you cannot contradict the existing terms of the document. I'm going to pause now for questions while people digest what I just dumped on you all. So some are saying some of the written things Oh, Nightbot, why are you being mean? Nightbot, come here. Why are you... There you go. Go away. Sorry about that, Sly. I don't know what... I have no idea what Nightbot... Nightbot is being... Oh, it didn't like how many times you use the ellipses. Sorry about that, Nightbot. Sorry about that. So Barontor says, some are saying some of the written things on WotC's website at the time says that the OGL wouldn't change. Would that be able to be admitted into evidence? No. It would not. Because it specifically contradicts this statement right here. Section 9 of the license. This is, again, the currently available document. And what they're saying is the question is not about the is not about change. They say it can't be revoked, and those are because they believe it is perpetual. And we'll go back to those because those are very specific terms and very specific. But the most important, actually, we'll just go over here. This is they're addressing section 4 right here. This is section 4 of the contract, the current OGL for Wizards of the Coast version 1.0a, currently available on their website. The two of you. All right. So section 4 specifically states, granting consideration. In consideration for agreeing to use this license, the contributors, that means every third party out there, Paizo, Kobold Press, everybody who's ever written their own thing and sold it to make money, on a platform that was not the DM's Guild. Again, the OGL doesn't apply to the DM's Guild. The DM's Guild has a separate licensing document, and agreeing to publish on the DM's Guild has different licensing rules. So, granted consideration. In consideration for agreeing to use this license, which is basically saying, if you're a third party, consideration is what is required for a contract to exist, right? Consideration in legal terms means that I am making you a promise, and in exchange, you're going to give me something, right? Your promise for a thing. So in consideration, as a promise for agreeing to use this license, the contributors grant you a perpetual, worldwide, royalty-free, and non-exclusive license with the exact terms of this license to use the open game content. So what does that mean? This sentence is really important to break down into a lot of pieces, so I'm going to blow it up so we can all see it. It's really big. The contributors here, again, we go back to our definitions, right? Wow, okay, it went too far. We go back to our definitions. Contributors means the copyright and trademark owners who have contributed open game content. In this case, that is Wizards of the Coast. Okay? So the contributor here is Wizards of the Coast. Grant you, the eponymous you, anyone who wanted to create content using this license, a perpetual. Now, this is a very important term, because perpetual has a different meaning in contract and licensing law than it does in vernacular English. In vernacular English, a perpetual license means a perpetual thing is like a perpetual motion machine, right? It is never ending. It goes on and on forever. It is quote unquote immortal, right? That is not what it means in legal definitions. A perpetual license, and this is very important. Perpetual here is a modifier, is a type of license. A perpetual license is merely a license that does not have any stated and express expiration date. Okay? I'll restate that. A perpetual license is one that does not have an express expiration date. It does not mean that the license cannot have an expiration date or an end date or a termination date or a revocation date. All it means is at the time of the writing of the document, there was no delineated point when this license would end. Okay? Worldwide is also important. That means that this license is applying to not just the United States, but everywhere that Wizards of the Coast does business and accepts this as a legal document. Everywhere worldwide. Okay? So you could be in Singapore, you could be in China, you could be in Cote d'Ivoire. It wouldn't matter. You are allowed to use this license. This license would apply but also again, this is very important. As a worldwide license, it is still subject to the laws of copyright and licensing in the nation in which you currently reside. What's the question, Sly? Again, so worldwide means it is based on anywhere that Wizards does business and where you currently reside. It is still subject to the laws and authority of a particular place. And we'll get into that because that is also included in this license. Oh, Cote d'Ivoire, Ivory Coast. It's on the west coast of Africa. So it's a worldwide license. It is a royalty-free license. That means you, the eponymous you, anybody who's out there, may use this content and this license without paying a fee to Wizards of the Coast. Now, that's only for the OGL. If you publish on the DM's Guild and you use DM's Guild material, you're paying 50% to Wizards. off the bat. Right? Like, anybody who publishes on Wizards of the Coast, or publishes on the DM's Guild, is agreeing that every sale they pay a royalty fee of 50% of the sale cost to Wizards of the Coast. The OGL and only material written under the OGL is royalty free. That means you do not have to pay Wizards any percentage of what you make on it. It is a non-exclusive license, which means that they are not limiting who may use it. An exclusive license is like saying, for example, Wizards has an exclusive license with D&D Beyond or when they did and hadn't bought D&D Beyond, for the all of the books and the setup that they were going through and the sales of the PDFs through D&D Beyond. Right? That was an exclusive license. The OGL is a non-exclusive license. It means anybody who's writing now can pick up and write a third-party content for under this version of the OGL. Okay? The next section underneath that, and then here's the very important thing. Offer an acceptance. By using the open game content, i.e. by using anything that is under the SRD, you indicate your acceptance of the terms of the license. By using anything under the SRD, you are bound by this contract. Okay, so we're going to go over here, and this is where we get to the point that we answer Barantor's question. And Barantor asked, so some are saying some of the written things on Wizards of the Coast's website at the time says the OGL wouldn't change. Would they be able to be admitted to evidence? No. And this is why. Section 9, right here. Updating the license. Wizards or its designated agents may publish updated versions of this license. That sentence right there. Done. Anybody who says that they can't do this, they're not allowed to do this, they're violating the terms, they're wrong. This sentence right here. Done and dusted. Now, are there ways in which you might be able to make an argument based on waiver or other concepts to say that maybe they were allowing things that they wouldn't have been allowed based on this license and have other arguments? Those are all legal arguments that you should, unless you have a law degree, don't make. That is my straight up answer. If you want to fight this, don't try and do it unless you have a law degree. But the argument that they can't revoke something, which is what people are talking about, right? They're talking about the term revocation, which is, again, a very specific term in legal parlance. It means I am unsaying what I said. I am taking this contract and revoking it. I am removing it. And people are saying, well, they can't do that. They have a perpetual license. And again, we go back to our sentence over here in section 4. A perpetual license just means it doesn't have a stated expiration date. It doesn't mean that they can't revoke that license. If they wanted to have this document be what is to not ever be gotten rid of, it would have said perpetual and irrevocable. The term irrevocable is not included in this license. And courts do not like to imply terms in contracts to begin with. If it's not specifically stated, they don't like to read things into a contract, basically for a lot of reasons of varying courts, but basically their concept of like, well, if you wanted something in there, you would have put it in there. And if if it's not there, I'm not going to force it to be there because it might be to the benefit of one versus the other. But this, by not having the term irrevocable in this section 4, or indeed anywhere in this contract, this is a document that can be revoked. Specifically, as Section 9 specifically states that updating the license, Wizards or its designated agents may publish updated versions of this license. It's there, this is a statement right here that would be really, really hard to... this statement right here would be almost impossible for somebody to admit parole evidence to contradict. I mean, first of all, you can't contradict based on parole evidence anyways, but because of that statement right there, you can't come back and say, well, we thought we would be able to have this license never go away, and not change at all. You can't say that. So anyone who's saying that they could, and again, termination of the license, there's a termination clause. This license will terminate. This license will terminate automatically if you fail to comply with all terms herein and fail to cure such breach within 30 days of becoming aware of the breach. All sub-licenses shall survive the termination of this license. That has to do with a lot of other things and ways in which you are writing and how third-party big-name publishers work. If any provision of the license is held to be unenforceable, such provision shall be reformed only to the extent necessary to make enforceable. This is basically saying that in this document, that if the court says, well, this portion cannot be enforced, oh, okay, well, sorry, court, we mistyped. We'll edit it and make it better now, and it won't be a problem. But you don't have to throw out the whole contract. The contract itself is still good. We're just going to get rid of this one little piece that you say we can't use, and then we'll fix it. So yes, Wizards of the Coast. So this brings us to a couple points. Number one, Wizards of the Coast this is a product that Wizards of the Coast created. Number two, if you do not define the terms of a contract, you're not going to be a very clear contract. 3, this contract has very clearly defined terms. 4, perpetual does not mean never ending and irrevocable. 5. Okay, we're at 5. 5, this license, it doesn't really matter if you say, I thought I said X, if what the license says is Y. Right? Because at the end of the day, the court will basically say, at the end of the day, if you thought you wanted Y, why does it say X? You obviously meant to say X. You signed the document. You published it. You've published it for 20 years with X included in the document. Therefore, I don't care what you think you wanted or what you now currently, 20 years later, with a major bag PR move and a different people in power, come out and say, oh no, I think we really said Y. Doesn't really work it. Exactly. The written word is king. And unless the written word is ambiguous, and that means that there are more than one, the court can look at a specific term in the contract and find that parties could be, a plain language reading of the term. And by that they mean not like If you pick like the OED, right? The Oxford English Dictionary, you can pick up the Oxford English Dictionary and there will be like definitions for words that you'll be like, wow, this is the 4th or 5th definition down on this term. Nobody actually uses it that way in plain English. If you meant to use that particular definition, you should have put it in the contract. And like, that's not ambiguous. That's just you trying now to get out of the way of the contract. But if there is a term where two parties could legitimately have a confusion, again, going back to our conversation about the chickens, right? You didn't specify what kind of chicken you wanted. You just said chicken. The court will look at it and then go, okay, there's a legitimate reason why these are ambiguous. But if there's no legitimate ambiguity, the court is not going to accept it. Even in California, which is where this would be litigated, probably, based on other things that would happen. Now, let's talk about the new document going forward based on what we know and what we talked about with the old document. So again, this is the new document. This new document is, a leaked document. It doesn't have any of this. It is a leaked document. I can't guarantee its provenance, but this is the document that people are talking about. So let's talk about what this covers and what it doesn't, and why actually the update, the concept of updating the license makes sense. How they do it, I would not accept. I wouldn't write anything for Wizards going forward. Based on this document. But let's look at it. So number one, this is an intro. And I'm going to read this to you, and I want you to think about things in your head. And we're just going to read the intro, and I want you to think about this in your head and think about and I will ask a question at the end of it, and we'll see if you can come up with this answer. Dungeons and Dragons, D&D, is all about creativity, both yours and ours. Throughout the nearly 50 years since the first release of D&D, Wizards of the Coast and its predecessor, TSR, have encouraged people to build new campaigns and material on the foundation of the Dungeons & Dragons base game. Historically, we have allowed fans, through our open game license, to make and sell commercial content using our intellectual property via the Systems Reference Document, SRD. This practice has continued for more than 20 years, and we continue to support it today. A lot has changed over the last half-century, including the rise of the internet, apps, Web3, and even virtual tabletop RPGs. Now, in 2023, we are updating the open gaming license to address some of these new realities and fix some of the loopholes and contradictions that made their way into the open gaming license during the time since its first release. One aspect of that is dividing the open gaming license into two pieces. First, a license covering non-commercial uses of the SRD, OGL non-commercial, and second, a license that applies to commercial uses of SRD content, OGL commercial. The OGL non-commercial and OGL commercial together make up the updated OGL. This revised license is intended to protect the D&D brand by reducing creator confusion, preventing bad actors from tarnishing it, and preventing large businesses from profiting off it without proper checks and balances. The actual license is available through the hyperlinks below, and if you are comfortable with legalese or somehow actually enjoy reading legalese, feel free to jump ahead to those links. We've included the explanations and examples alongside the legal language to help make the OGL easier to understand and comply with. You can get to those comments by clicking the link after each section. If, on the other hand, you would like to start in a plain language of how the OGL works, you can start here with the FAQ section. So I want to go back to this point right away. This is a leaked document. This is not the license. This leaked document isn't even a leaked document of the license itself. So, that's a concern. Remember how I said that there were caveats about how this is a document that exists? This document does not actually include the hyperlinks. It is not a license itself. It includes generic explanations, but they're mostly commentary. This document that we are looking at right now, if it is real, and again, if this document is real, is their PR interpretation of what the license would say. Some are wondering if the hyperlinks require a sign-in, so they're harder to leak. No. They wouldn't do that, Barantar. Because here's the thing: to be an open license, labeled as just an intro. Exactly. This is, and that's just that's the intro to the whole thing, right? So, Barantar, the reason that explanation isn't going to work has to do with how the law works. So I know I mentioned earlier that people, everybody who's over the age of 18 has signed a contract in the United States or worldwide by looking at insurance. There's an earlier contract that everyone over the age of 13 or even younger than 13, although they're not currently, wouldn't be bound by it because they're minors and that isn't how that works. But in the United States, how many times do you click the TOS button on a website, right? You click the TOS. For the contract to, and by click the action in the US and Canada and Europe and England, all the action of clicking and saying, I have read and agreed to these terms on a TOS is a binding signature on a contract and means you have read and agreed to those terms. However, you must be able to read and understand those terms before you click the button. That has been a court ruling. They can't just give you a button. Okay, so if you had a pop-up and it said, you must sign that, click here to sign the TOS before you go forward, and there isn't an active hyperlink right there to click to send you to those TOS terms, that is not valid. That is not allowed. It is not permitted. Now, you don't have to actively click the hyperlink to then click forward. That would be acceptable. But then that's on you, right? That's on you not reading the TOS. If they put the hyperlink behind a sign-in, then it's not a valid license. It's not a valid contract because you didn't have the opportunity to read the license yourself. And this document that's been leaked and we're reading right now does not constitute the license and therefore cannot constitute your agreement to the license because the FAQ is just someone's interpretation of it. But you might be able to read through and go, okay, you didn't talk about terms 6, 7, and 8, and 6, 7, and 8 are real important. And if I had read 6, 7, and 8 and had the ability to read 6, 7, and 8, I would not have agreed to this contract. So they can't put the hyperlink for an open document contract, a TOS or an open or a license like this, behind a paywall or a sign-in. Unstable Leo says, does that hold if the sign-in required is for a service not covered by the TOS in question? Yes. Yes. Like, because the TOS has to be covered, if I'm signing into, say, if I'm signed into Twitch and I'm using my Twitch sign-in as a validation for, say, Pretzel, right? Because Pretzel is linking to my Twitch and whatever. They can't put the TOS for Pretzel behind the login for logging in with my Twitch. It means that I cannot, You can't put the link for the TOS behind a paywall, behind something that would require... You can make it a link where you'd have to click out and go read something else and then come back to that page and then sign it. That's acceptable. You don't have to put it visually in front of people in the moment. You can just give them a hyperlink. That is allowed. But you can't make it so that they have to sign into something before they can read the document. Because the act of signing in has been argued and has been accepted in courts as an agreement to the terms. And because of that, you can't agree to terms if you don't know what they are. Which is what it is. Hawkeye, welcome in! Welcome in, Raiders! Hello! Hi, I am your friendly neighborhood Prax. Welcome to the channel. Today we are chatting about the OGL and we are looking at the leaked document about the possible OGL version 1.1. Welcome in. We hope you are doing some great times. If you're coming in with Hawkeye from the raid, thank you for that subscription, Hawkeye. I appreciate it. If you're coming in from that raid, go ahead and click the little circle button below so that you can count as a viewer and not just a raider. And Hawkeye, if you need to raid and run, go right ahead. We appreciate you coming in. But you're coming in at just the perfect time. As we're sitting here chatting about the, Oh, you're getting to the mouse droid? Ooh. Look. And because I'm going to edit this out in the highlight anyways and won't go up on YouTube, I want everybody to know that I would love a mouse droid. Like, my life would be 50 times easier if I had a mouse droid. Not a Roomba, a mouse droid. But we're going to go back. So, this is, again, the leaked document, and this is not the terms of a license. This is an explanation of someone else who is probably not a lawyer, because this terminology is very, very flowery and not helpful. So this is somebody's attempt to take legalese and make it easy to understand. Okay. That's beneficial, but it's not the terms of the actual license. And this is why, if this is all I am given and looking at this, my first thought in my head is, this isn't the terms of the license. I'm not doing anything until I can actually read. Exactly, Bonnie. If this is all I am given to read, I am not doing anything for Wizards of the Coast. I'm not touching a thing from Hasbro. I'm not touching D&D. I will not publish or sell anything. And now here's a very important thing. I'm going to zoom to this screen so you can see it. The OGL has only ever covered printed, written materials. Your streams, your virtual home games, art, fan art, none of that has ever been covered by the OGL. So them coming up with a document where it is more specifically stated that's not covered by the OGL makes sense. The belief as they go into a new version, because I don't care whatever they say about 1D&D, it's a new edition. With them going into a new edition of the game, creating and updating the license makes sense. However, yeah, see, here's the thing, Hawkeye. That homebrew module you're creating, and this is a very important question, that homebrew module you are creating, if you used what is considered under the SRD, and going back again to the original version, if you use anything that is referenced under page from 3 to 98 of the original Open Gaming license, and it is published as a printed work on something other than the DM's Guild, I want to preface this, on something other than the DM's Guild, your module, your campaign setting, well, maybe not your campaign setting if it doesn't include any mechanics and instead only includes your setting world, that would be covered. The stream of your homebrew, no, it doesn't matter. That's not an issue. Your fan art, the map you create of your homebrew, none of that is part of the Open Gaming License and is required. And indeed, you would not be required to get a license to create your own map for your own game for your own homebrew. That is your creation. The only thing that is copyright Wizards of the Coast is the explanation and term expression of the ideas in the game. The mechanics of the game cannot be copyrighted. The action of rolling a d20 and adding a modifier cannot be copyrighted. The expression of that action can be. The DM's Guild does not use the OGL. The DM's Guild has a different document, and we can look at that right now. And I will just pull up here the DM's Guild license. Where? Oh, come on. Go to the actual page. Okay. Okay, this is under the support. This is the getting started, right? Ownership and license OGL questions. Here we go. We're going to click on this right here. So this is their breakdown. This is publicly available on the DM's Guild. You can click. I'll put the link in chat. Oh, no. This is an important conversation to have. And this is an important point where people get so confused. And it's very important. Under the DM's Guild program, you can publish D&D material that has no setting or uses the Forgotten Realms, Ravenloft, Eberron, Ravnica, Theros, Strixhaven, Radiant Citadel, or Spelljammer. You'll notice that it doesn't include anything from Greyhawk, and it doesn't include anything from a bunch of other settings. The reason people... But this right here is not included in the OGL. The OGL specifically prevents you from saying things about the Forgotten Realms. You can't talk about things of using term characters, places, people, definitions from any of those setting books under the OGL. The OGL is for homebrew content. The DM's Guild is to use things that are tied to already existing Wizards property. They are two different platforms. Now, I have stuff up on the DM's Guild. It'll just live there. And I'll collect my royalties and be happy. But I'm not going to keep publishing on the DM's Guild, and I haven't. If you want to use content using the 5th edition rules for D&D, you can publish under the OGL or the DM's Guild. I want to publish my own original campaign world using 5th edition rules. You can do that using the OGL, not on the DM's Guild. I want to print and sell my 5th edition product on my own. Use the OGL, not DM's Guild. Publish content for all of these other settings. You can't use the OGL. You have to use the DM's Guild. I want to sell my product in the official online marketplace, which is the DM's Guild. You have to use it that way. I have my content rated by the largest network of players. This is all that I'm selling you to use the DM's Guild. Have my content considered for additional publication by Wizards. By putting your content on the DM's Guild, it is written into the license on the DM's Guild that Wizards can look at what's on the DM's Guild and be like, ooh, I like that. We're going to integrate that into official material now. And usually, from everything I've heard, they at least nominally credit people. Whether they give you a royalty for your idea or not is entirely irrelevant, because they're telling you that they have the right to do so. So publishing on the DM's Guild means it could become Wizards property. Have my content considered for inclusion in digital games, and that means that anything that any product that licenses information or things from the DM's Guild from Wizards of the Coast is included. have my content considered for inclusion in Wizards marketing. By all of this, Wizards does not own any of the unique IP you create with your publications. Wizards does not own the IP that they contribute. Plus the DM... Wizards does own the IP that they contribute. Plus the DM's Guild agreement will grant Wizards and other DM's Guild authors a license to use your IP. Not just you. The minute you publish on the DM's Guild, anybody on the DM's Guild has the permission to use that material to create their own work. And because that is the way the licensing works on the DM's Guild. It's not the OGL. It's just the way it works on the on the DM's Guild. Lurk away, Simon. So, DM's Guild. DM's Guild also includes taking a 50% cut of your any sales you make. The OGL does not. But there are much fewer places to publish under the OGL. Drive-through RPG, your own platforms, all of this. But again, okay, so OGL, better for the creator, but more limited content that you are permitted to use from Wizards properties. SRD, better for, or SRD, all of the content that you are allowed to use under the OGL. You may also use SRD content under the DM's Guild, but the DM's Guild offers you more pieces that you can use. The DM's Guild is also heavily weighted in favor of Wizards. Like anybody who comes at this new license and says, why am I paying for this royalty? I'm like, yo, you did not, the OGL exists. The DM's Guild is existing. There might be some settings that are covered by either license. No, actually, the OGL specifically states that it only covers it only covers specific information and generic licensing, not everything. Oh, not covered by either license. Yes, there are settings. Greyhawk looks to be a setting that is not covered by either license, and that might have to do with who the original author of that setting is. The OGL covers some, it doesn't really cover settings. It covers, it doesn't cover, it covers other things other than setting information. So that's a thing that exists. But the new license, and again, this is a leaked document. I cannot verify its authenticity, but this is not specifically the license. This is somebody's explanation of what the license means. And is not, therefore, possibly accurate or understood correctly. There's a lot that can come from this. This isn't the specific terms of the license, and without reading the specific terms of the license, I have many, many concerns. Like, the fact that this is the leaked document gives me concern. There are concern. I am a concern. Like, that's a thing. I'm a concern. All of these. But this is the document that is currently available, so this is the document I'm talking about. And based on that, we have the issue of how to phrase this. So this document specifically states that it is separating the license into non-commercial and commercial use. And I have some issues with that. Because if you're doing it for non-commercial use, then it wouldn't matter. Right? Like, if it's a non-commercial use, if there is no commercial use for what you're doing, then you shouldn't need a license for it. Because of the fact then it's about the game. And that means that they're basically saying that anybody who plays the game needs a license to play the game, but the purchase of the game is the license. That's the one that bothers me. I need to read exactly how they're breaking this down. And I would want to read the actual terms of this license. A commercial license makes plenty of sense. Unless they're separating out non-commercial and commercial to mean those who sub-license and those who don't. But that's the thing, Krellin. Krellin says, Wizard still owns the copyrights and you need a license to publish even if you're publishing for free. But that's the thing, Krellin. If I am... How to phrase this? The act of publication, if I am not commercially publishing something, it would fall under the concept... would either be under the aspect of the game where it is playing the game and I am using the terminology to discuss the game content. And if I am not selling anything, then it becomes an issue. If, however, the term is subjecting to a concept of the difference between general licensing and making the license what under commercial mean apply to what we call the UCC, which is the Universal Commercial Code, which isn't actually universal. It's just mostly universal. So there are reasons why that document might exist as that separation. I need to see the terms to discuss this. And if you're talking about generally people who are creating things for whom there is no financial gain, then they are not entering into the marketplace and they are not offering it into a commercial marketplace, so they're not impeding on your license. Or they're not impeding on your property. It's the fan fiction defense, and it is part of the attribution. So without giving an attribution, assuming that you would still have to acknowledge who owns the property, they don't need a license to do that. And it gets a little fuzzy and complicated as an explanation. But it is Oh, Pirate, welcome in! Hello, everybody! Thank you for joining me. How is everybody over going? I am your friendly neighborhood Prax. Welcome to the channel. We are doing some chatting. Welcome in. Mandy, welcome in. Thank you for both of you for bringing in your communities. I really appreciate it. Hello, everybody. I am your friendly neighborhood Prax. Welcome to the channel. I use she, her pronouns. Welcome in for that. Thank you for those wonderful raids. I do appreciate both of them so much. We are chatting. I do a lot of different things. Today we are chatting about the OGL. And the leaked document and all of those wonderful things. Thank you both of you for coming and bringing your wonderful friend, Unleash the Gradehounds. I appreciate that. How was the end of, you guys were playing, Fortnite. How was the end of Fortnite going for you guys? I hope you had a lot of fun. Thank you everybody for coming. We've been talking about, I managed to get a copy of the leaked document, the leaked document is very interesting because number one, it is not the license. The leaked document that people are talking about is not actually the license. It's an FAQ, an explanation of what they're saying the license means, but it doesn't include any of the actual terms of the license, which is a concern. So, oh, I have to wait. I can't do it. I don't like that I can't have an active. So the thing is that, again, if you're creating something from, well, no, Krellin, that's not true. The US is, okay, so Krellin is saying that the US has problems with defining fair use. It doesn't. It has very clear-cut definitions of fair use. It has very clear-cut definitions of transformative works. The problem is that people interpret, non-lawyers interpret fair use to mean a permission. It is not. Okay? It is not. Fair use, it is a defense. And by using fair use, you acknowledge that you are infringing on somebody else's property, but it's okay because you're not actively harming their commercial interests, or in the case of this license, probably also their trademark interests. And one of the biggest things in trademark is what is called good faith. And that doesn't mean that we all like Wizards of the Coast or Hasbro, probably more accurately in this instance. It just means that we have a knowledge and an understanding of the symbol. If we look at that ampersand that looks like a dragon, we immediately know who it belongs to. We immediately make a connection between that image and font and all of those things to the product of Dungeons and Dragons. There is a knowledge and understanding about that, and we have certain beliefs and ideas tied to what that ampersand means. Now, the language of fair use is often muddled by a lack of understanding that there is two different tests for fair use that are kind of really combined into one. And people, so there's what is called the Rogers test, which is the most frequently used in creative spaces, film, video games, music, books, anything like that. The Rogers test is like step one. And people will kind of assume that the Rogers test is already valid and that you can go immediately into step two, which is the four-factor test of the four-factor test of what is something fair use or not. So the Rogers test basically looks at a thing and says, at its core, is number one, is this infringing on somebody else's work? And number two, is this infringement artistically necessary for the expression of this work that you're creating? Okay, you're infringing, And it is, does the Rogers test require super serum? No. But sometimes understanding it does. Specifically, the Rogers test references a case out of the 80s about Ginger Rogers. It's not Mr. Rogers, it's Ms. Rogers, Ginger Rogers. And Ginger Rogers objected specifically to her name and likeness being tied to a film that was really a quasi biopic that was really not a great depiction of her. And she sued under their use of her IP, which she was suing too early to really get into, like, false use of her likeness. It wasn't really what she was suing under, and probably would have had a different outcome if it did. But the case itself has to do with the fact that the movie needs to talk about instances made the argument that it had to talk about these particular instances and things that that Ginger Rogers claimed were her intellectual property because they occurred to her in her real life, and they were things she said or did or wrote down. Because they were doing a biopic about her and a bunch of other people at the time. And it was artistically necessary for the expression of this particular piece of art to understand that. A more modern use and understanding of the Rogers test is actually going into video games, which is usually tied to something like Twitch, is a case of Activision versus GMC. So Activision owns Call of Duty, right? And in 2013, GM sued them for the rendering of a Humvee in the Call of Duty game. And it wasn't just in the background of the image, it was you interacted with it, you went into it, you looked around, and all this. And the argument was that based on the Rogers test, there was an artistic necessity for having this Humvee in this video game because it created a sense of realism about a war instance, right? It's Call of Duty. It's expecting to be quasi-real. There's no there's no it's this shape and image, and more importantly, and this is why the lawsuit came up, it was specifically about trademark. They had the trademark symbol for the Humvee actually on the vehicle that you could approach and get into, and therefore the case was about what we call a cause for confusion. Did people believe that GM had licensed this to Activision? Did people believe that GM was actively involved with Activision? And the court ruled, well, if I'm playing a video game set in a war setting with an American army, and I know that the American army uses Humvees, I'm going to expect to see a Humvee in the background. Having it there has an important point for the artistic expression. All of these are things that are important. That is what's called the Rogers test. The next step below that is about the fair use. And fair use has 4 factors. Number 1, how much of, and then this is the first thing. Number 1, excuse me. Sorry, I had the hiccup for a second. So the first thing is, how much of this work is being used, right? Like, the assumption is that the work is copyrightable. That is the first thing. If it is not copyrightable, then the defense of fair use isn't valid. And courts will weigh what is called the 4 factors of a fair use. It's usually called a Polaroid test. which are called the Polaroid factors, which are important. And so these are usually tied to trademark, although it can also be applied to copyright. It's not called the Polaroid factors when it applies to copyright. It's also applied. All right, so the first thing is the strength of the mark, or the strength of the owner of the copyright. Like, how is it immediately identifiable? Does it have a secondary meaning? Is it arbitrary, fancy, and suggestive, right? Like Dungeons and Dragons by itself, the pure term Dungeons and Dragons would be if the game that Wizards of the Coast created right now is a thing, and if there was no idea that Dungeons and Dragons existed, and somebody today came up with that game, the term Dungeons and Dragons would possibly be considered arbitrary, right? Like, but at the same time not, because it is enough to give you an idea about what something is. It's giving you it's not going to be a very, very strong mark, but it could be one that has some clarity about it. You want things to be unique. If it's just suggestive or arbitrary, then it would be considered a weak mark. Or if it's suggestive or fanciful or arbitrary, then it's considered a strong mark. Sorry, I misspoke there. However, nowadays, Dungeons and Dragons, if I say the term Dungeons and Dragons to you, that has achieved what we call secondary meaning. It's like saying McDonald's, right? Like, McDonald is a dude's name. And 9 times out of 10, you can't just randomly trademark or copyright a person's name. It'd be like, nah, man, I've got like 6 people who have the same name. It's a thing. You can't force me to say that I'm violating your intellectual property by saying I'm using my own name. However, McDonald's is has achieved what we call secondary meaning. Like, right? It is such a huge, popular, well-known thing that it doesn't matter. Everybody knows what knows what McDonald's is. Everybody knows what Dungeons and Dragons is. I turn around and say, hey, we're gonna, you want to go to McDonald's, you know what I'm talking about. So there's a very strong mark. That means it's one of the factors you're going to consider. The other one is, how similar is this work? Well, again, this is about trademarks and whether these are you're infringing on somebody's trademark. Less about if you're infringing on fair use, and I'll come back to the fair use issue. But it's the same similar 4 factors are used. But this is about the image, and we'll get back to the copyright for terms in a second. So that's the thing. Okay, so Krellin points out the franchise actually lost a case against a dude named McDonald who opened a restaurant. Yes, because it also has to do with the issue of cause for confusion. How similar are they? Like, the issue in that particular case, Krellin, is the fact that, yes, they were both restaurants. Yes, they had the both same name. No, they were not serving the same kind of food. No, they weren't serving the same kind of material or marketing. And the images weren't confusable. And then the understanding that how understanding is the consumer. Those are your 4 Polaroid factors for trademark. How similar, and that's all based on visual, right? Like, if I have this image and this image, how easy are they going to be to confuse? The 4-factor test, and I that was me messing up, because it's late. And being like the Polaroid test, and like I'm explaining the Polaroid test, but that's not the actual test I want. The test for fair use, which is also a 4-factor test and is tied to the Rogers, is different, and we'll get to that in a second. But I want to answer Dragonicor's question. Where does something like D&D sit when so many people use D&D when they mean other rule sets that aren't even part of the D20 system? So, this is really important. This is what we call a mark that has become generic. Very similar, Kleenex versus tissues. A Xerox versus a copy, right? Fun fact, I'm going to say something and I'm going to ask you a question. I'm going to say something and you're going to be shocked. Did you know that escalator was a trademark? Right? Did you know that escalator was a trademark? Yeah, the original escalator is actually you can actually go visit the original escalator if you go to Macy's Herald Square in New York City, and they are a beautiful. They still use them in the old building, and they, except for the one that was taken out and put in the Smithsonian, but all the other originals are still there. The people who work on them have some very, very kind of exactly. They didn't robustly well, no, Krellin, that isn't the point. It wasn't about them defending the trademark. And this is important. A trademark becoming generic isn't about defending the trademark. It's about the term of use in commerce and achieving a different meaning. If I said, because escalator wasn't about defending it. No, Skexy, it is not even the escalator of Theseus. They still have the original treads and the original handrails and the original brasswork. It's just that the mechanics, and actually I think most of the original mechanics are still there. But the people who have to repair them have to be specifically trained into maintaining these. They're absolutely gorgeous, and you can go, they're very beautiful. It's like, ooh, the aesthetic on these. But it's like, again, going back to the Kleenex versus tissues issue. It's not about how vigorously they defended their trademark, but it's about the fact that for so long it was such an identifiable thing that if I turned around and said, hey, do you have a Kleenex? And it didn't, and you said sure and handed me just a tissue, regardless of what brand it was, whether it was Kleenex or Scott's or Bounty, I think even makes facial tissues. But you still ascribed the idea of a Kleenex to the product and not to a particular brand or trademark, then that is a separate issue, right? That is the trademark losing its uniqueness and becoming generic. D&D, yeah, exactly. Like some people call any cola a Coke. But when I say I want a Coke, and you please do not try and give me this Pepsi crap. It does not taste the same. I do not want Aspartame in my caffeine. Hey Tanya, welcome in, by the way. So, exactly. Well, also Coke is the South is the land of Coke, and if you're ordering a Coke and you're not getting Coke, there might be a problem. Exactly. What kind of Coke you want? You want vanilla? You want cherry? But so we have this concept that a trademark can become generic. And when a trademark becomes generic, it loses its ability to be defended as a trademark for infringement purposes for a lot of reasons. People saying, oh, I play D&D when they're talking about any tabletop RPG, regardless of system or mechanics, is a big sort of making D&D generic. Which is why so from a legal standpoint, I'm going to say these two things, and both of them are true, and neither of them are me choosing a side, or neither of them are me defending this particular document. Exactly. People calling anything with dice and actions a D&D, it isn't. That's why I'm very, very particularly, well, I always have been very particular about language, because I am also studied to be in... Oh, yeah. Do not call Motherlands D&D. Motherlands is its own thing. It is its fabulous thing. And if you don't know, oh, hey, go follow Tanya, the wonderful Cipher of Tyr, on everything and appreciate the joy that is Motherlands, because that is a wonderful system written by some wonderful, fabulous people with a great idea and great people behind it, and something that should be supported. There, my shill for my friend. Haha. But this goes back to the concept, two concepts that are tied together, right? The making of a thing generic because people understand and have a greater idea or become so inured to the trademark that the trademark becomes dominant across the entire marketplace, and so much so that the product, regardless of who makes it, is tied to the trade name. This is an issue for D&D. It is because of this issue and ties to the open gaming license and things like that nature that the fact that they wish to create a new version of this license makes sense to me from a legal standpoint. Like, I may have gone to law school specifically because I was like, yo, open gaming license, how does that work? Like, how, I have questions, I need explanations. Oh, well, I'm gonna go to do law school and do IP law. That is literally my thought process and why I chose to do this specification. I have written I have written at least one paper a semester, the entire last 5 semesters of law school, on open gaming license and how things like Twitch and YouTube and D&D and Wizards of the Coast apply that kind of licensing. It's a really big thing that interests me a lot. I'm a nerd. It's fine. I'm okay with this. But to go back to the point about generic, so the issue with something becoming generic means it begins to lose its protectability. So to pull back on that, you need to make sure that you are not oversaturating something so that it becomes the only identifier, and you vigorously defend your own trademarks and copyrights for 2 reasons. Number 1, copyright does have an expiration date. It's really freaking long and is complicated, but it does have an expiration date. Trademark doesn't. Someone, a company, a person, an entity can renew their trademarks indefinitely as long as that trademark is being used in commerce with a particular item. Usually it's like you have to renew it every 12 to 15 years. It gets a little fuzzy because there have been times that the USPTO, the US Patent and Trademark Office, has changed their requirements on how often you need to renew it. So say roughly 12 to 15 years. But, but because that trademark will never expire, if it becomes too generic, it will basically be removed, right? You have your right to protect it, to sue about it, to argue that somebody's infringing your trademark. Exactly, Harmony Gold. Is lost if it becomes too generic. You can also lose your right to defend your copyright or your trademark if you don't defend them. And if you aren't actually defending the licensing or if you aren't defending the mark in commerce, it creates what is called a waiver, right? Usually it requires it usually requires more than one. Let's take, for example, a more generic, more common ideology, a waiver. And this is, again, take this caveat with the fact that different people have different rules and different states have different rules and different counties and towns have different rules and laws. But most states, again, most, goes back to our "it depends" being the most important thing that a lawyer will ever tell you. Most states include a point in their state laws that basically says you cannot, if you are a renter and you are renting from someone and then you fail to pay rent 1 month, but your landlord never made a comment about it, and then you paid the next month, the landlord can't go back and then evict you for failure to pay over the month they did not comment on. They created a waiver by not saying anything, by not making any comment, by not filing anything, and the fact that basically they said, okay, well, it's not important. If, however, that is what we call a waiver. The original OGL, going back to this, again, this is the document that the first document we've been talking about. This is the current OGL. This is the current document that only applies to wizards. As it currently exists, is both very generic and very specific. Like, the definitions are very specific. It doesn't allow you to use the settings. It doesn't allow you to talk about any of these particular, you can't use the Red Wizards of Thay. You can't talk about anything that's very specific only to the Forgotten Realms. All of these. Yeah, aspirin is a generic term, is a term that was specifically a trademark at one point, but now it's become specifically generic. Under this original license, it did not cover particular things. This license was only supposed to be used for written published materials. And then Paizo comes out, right? Like, this is not me going after Paizo, right? I want to preface this. This is not me going after Paizo. This is not me going after Kobold. This is not me going out with anybody else. But Paizo comes out and starts publishing all of their works. Okay. This license is allowing you to do this. We're not going to go after this, but at the same time, there's a lot happening here, and are we okay with this? I guess we are. We're not going to argue it. Somebody could say that counted as waiver, and I have seen arguments by lawyers online that you could make an argument that 20 years of history could count for waiver. However, I go back to this previous clause, this sentence right here in section 9. Wizards or its designated agents may publish updated versions of this license at any point. They can just choose what they want to publish and change that license if they want. And they don't need to worry about having a waiver involved, about whether or not they had originally said yes or no to something. So this is a lot, right? Yeah, if Wizards hadn't pulled the contract. Look, I'm not involved. There's some interesting things that came out of that are Paizo's existence among them. Yeah, Paizo, some people, which is really interesting. Okay, so for those of you who don't know, I also talked about this earlier. There are people who are arguing online that you can choose what version of the license you operate under. That's not true. Once the license has been updated, that is the license. It is the only document that is giving you permission to do things that exist as it happens. Paizo and 3.5 aren't really part of the SRD at the moment. In fact, the SRD only applies to 5th edition materials. So, pretty sure that Paizo already has its own private agreement. But the license, you can't pick and choose what license you operate under. The license that is offered is the one that you're working under. I'm sorry. Like, there will never be a time that somebody says, well, I, as a third-party writer, am going to publish under the OGL version 1.0a instead of OGL version 1.1. Right? Like, Yeah, Pathfinder 2nd Edition still has the OGL in it. Yeah, because they specifically use terms and spell names and other copyrighted content. Again, remembering, mechanics are not copyright, right? Like, the mechanics of 3.5 edition are not copyright. Anybody could write a system, use a game using those mechanics. It's the expression of those mechanics that's copyright. It's the specific names of spells. It's the specific names and descriptions and generic terms that people are so used to seeing. Those are copyright. But the action of having an ability score plus or minus on a D20 roll, that's not copyright. I could write a game about that right now and, probably wouldn't sell as well as D&D, but would not be in infringement of their copyright. The D20 system cannot be trademarked. Again, mechanics, not trademark, not copyright. Now, the image of the ampersand or the D20 with the particular ampersand in it, or a particular expression of the D20 is subject to copyright, yes. But a trademark, the mechanics themselves cannot be trademarked or copyright. Similarly, if you go online and you get, you're looking up a recipe online and you come across this blog and there's this, 50 pages of explanation about how great they found, this moving emotional explanation of their mother and their grandmother, and how this recipe is very important to them. The reason that is on that blog is because the actual recipe itself is not copyright. But the everything else is. And so the expression of that recipe is now copyright. Unstable Dios says, I dug out a copy of the D20 Modern book, which is why I asked. It would appear they believed it could be trademarked at the very least. Now, here's the thing. The mechanics can't be. The action of rolling a particular die and adding a modifier to it can't be. But, this is a giant caveat. Companies and corporations will try and do something regardless of whether or not it's really allowed, and it basically is allowed until somebody challenges them and the court is like, no, you can't do that. Actually, Barantor, the reason, Coca-Cola is under what we call a trade secret, right? Exactly, their recipe itself is not copyright. However, the recipe is not, isn't under copyright. But the formula for Coca-Cola, which includes both the recipe and the formulation and the process, is under trade secret. And fun fact, when I was living in Atlanta, one of my very good friends and roommates dated one of the 3 guys who had a third of the formula. The recipe, the Coca-Cola divides the formula. No one person knows all of the steps involved or all of the pieces. This is what is called trade secret. And trade secret is a methodology by which usually a company, but also a person, intentionally tries to keep something secret by not sharing the information, by not giving that information away, by defending it at all costs, and doing everything they can to make it secret. It's the keep it secret, keep it safe comment. And by the action of trying to keep it secret, they make it protectable. And if somebody came in and stole the recipe, they would be allowed to defend against that as an infringement case. Now, you can pick up a bottle of Coke and perform a chemical analysis on it and recreate something based on that chemical analysis, and you are not infringing on their trade secret. But it will not be a Coca-Cola, and it will not be 100% accurate. Oh, no, Cold Drake, those 3 people are never in the same room together. let alone on the same plane. So there are a lot of things that go like that. But when it comes to D20 mechanics, again, those cannot be copyrighted. The image of what a D20 symbol could be trademarked. The name Dungeons and Dragons is under trademark. You know what we could even do? Haha. We can go. You want to see something? I can show you something. USPTO trademark search. So this is a public database. You can access it. Anyone can do this. You can look up their trademark database, which is the TESS. It is, it's complicated, and it doesn't have a great UI because it is, again, based on a federal agency from the U.S. Patent Service. You can word or design search freeform. This option allows you to construct word or design searches using a Boolean logic and multiple search fields. You can do basic world search. But what you can do is you can actually look up Dungeons and Dragons and include, where is it? Games is international class. Let's go under international class. That's not what I wanted. Crap. Come back. Submit query. Cool. All of these, Dungeons and Dragons, Advanced Dungeons and Dragons, Dungeons and Dragons Notebook.com, A Tale of D20s, The Dungeon Run, Endless Dungeon, all of these are TSDR. All of the ones that are marked dead are dead because they have not been revived. The Dungeon Run, however, is still live. The Endless Dungeon Saga, that one's dead. You can use that one. Dungeons and Dragons Encounters, both of those are dead. All of these are currently dead. Advanced Dungeons and Dragons, here we go. Under TSR is now dead, but Dungeons and Dragons Against Others are not. So these are the most common Dungeons and Dragons. This one is still live. This trademark right here. First in use in commerce, 1993. Typed drawing, serial number, filing date, June 11th, 1991. So its first use in commerce is actually after its filing date, which is not actually uncommon, particularly if they already had existing trademarks on a similar name, and therefore they filed before to cover something that they were eventually going to use. Published by opposition in February of 92. That means that somebody made a claim against it, and then was registered in June 24th. TSR Corporation, Wisconsin. Last listed owner. Here you go. So this is the thing. The original trademark includes the original registrant, which was TSR, and then the current owner. The last listed owner is Wizards of the Coast. And you'll notice that it is incorporated in Delaware and includes a website as an address in Washington. The attorney of record is Chad M. Smith. Don't know them. It is currently live. It had a second renewal. So it had a 6-year renewal, it has a 10-year renewal, and it probably had a 15-year renewal. Yeah, that makes sense. Yeah, exactly. Koldrake is talking about the fact that in 1996, several corporations lost executive officers on a plane crash in Croatia. The business world was stunned, and that's why Coca-Cola keeps their secret trio as far apart as possible. Yep. Also a large number. It's why that's not even the first instance. There was actually a case in the 70s of a major corporation that had all of their C-suite on a plane, and the plane crashed. And that was a bad time for that particular company. But these things are the trademark, right? So looking at all of this, I'm doing a breakdown and introductory IP law. Welcome to the channel. Hi everyone. If you came from Pirate and Mandy's channel, I really appreciate you being here. We have a lot of fun, and I get to spend time talking about IP law. So Delaware, Kuldrake asks, isn't Delaware one of those safe states to incorporate in? Delaware is the state in which major, regardless of where else you are incorporated or have a location, almost every major corporation in the world, every major global corporation and every major corporation in the United States incorporates in Delaware, because Delaware has the Court of the Exchequer in Delaware has some very stringent, very forgiving corporate-friendly rules, but also a lot of very particular rules and understanding. And so it's one of those, yes, Delaware as a state is friendly to corporations, but at the same time, there's a body of history of corporate law because of that friendship to corporations. That means that even in states where other than Delaware, most courts are going to be like, oh, well, Delaware talked about, what did the Court of the Exchequer in Delaware say? What did the Third Circuit say? The Third Circuit being the Federal Circuit of Appeals, dealing with New Jersey, Delaware, and Pennsylvania. Second Circuit is the state of New York. That tells you everything you need to know. The Second Circuit is the state of New York. The First Circuit is New England. But going back to this, right? So this document, wizards can change. And we'd already talked about previously, because the fact that wizards can change, anybody who's saying online, oh, the new OGL can't be, they aren't allowed to do this, they're not, this is wrong. No. Wizards can do this. It's not good. It's a horrible, bad PR move. It's probably going to cause lots and lots of problems. And without seeing the actual terms of the license, I can't say if it's a good or bad or anything. But they have the right to do this. And going back to my much earlier statement saying, again, this is not me defending Wizards or Hasbro, their parent company, which is even more important. Hi, Hasbro is probably the ones who have written this. That made this decision about this new change. The concept of a license means two things. One, you're giving permission to somebody to use something, right? Okay. So a license in legal terminology means that you are giving permission to use and utilize and exploit. The license means you are allowing somebody to use your product, something you own, and you're saying, yes, you can use it. However, that comes with certain responsibilities on the person who's giving you permissions to be able to future defend their right to grant that license. One of the two biggest, and which really kind of boil into one, the biggest responsibility that goes with licensing a thing is to, and I'm going to use this term very specifically, police that license. And I don't mean cops. I mean police as in pay attention to how that license is used and exploited. And if you do not, it creates what we call naked licensing. That doesn't mean that folks are running around, in wearing nothing. It means that you have given so many people permission to do whatever they want with your product, and you're not coming after the people who do things that are against the rules, that it's obvious to the courts you don't care about this product anymore, so we're going to remove your copyright and your trademark, and anyone can do whatever they want with it. That is what is called naked licensing. It removes your ability to defend and go after, exactly, use it or lose it. Now, we can all have very complicated feelings about the great mouse, and what it does or does not do. But the fact of how consistent across the board Disney is in their legal department by saying Disney does not actually care about grandma living in Illinois selling little blankets with Mickey Mouse on it. Disney does not actually care. However, Disney does care about being able to protect things in the future, and I'm gonna go to the next song because I'm a little grating on the ear and I don't like Pretzel. What you doing? This is not. I don't like this one, Pretzel. This is not chill. There we go. So if you have, how to phrase this? Disney is very consistent. They basically will say, anyone who is infringing our trademark, copyright, trade dress, trade secret, any of the above, they will all get the same cease and desist letter. There might be a few different paragraphs at the beginning that basically are like, hey, we don't want to have to be evil mouse here, but you're breaking the rules, please stop. And usually a cease and desist letter is good enough and people stop. If, however, they don't, then you have to sue them. Because if you don't, then you're basically saying, well, we don't actually care about our license, we don't actually care about the thing, we're not going to defend it, and the court will turn around and it's like, oh, well, you're not defending it, you don't care about it, don't means you don't need it anymore, we'll take that and let somebody else have it. The fact that the open gaming license exists is intriguing. Conceptually, right? If you think about what I just said, right? There is this concept of naked licensing. If you're not actively controlling what people do with your license or what they're creating with your license, then you could lose your right to protect your license and your IP and your rights for anything tied to that license. But the OGL is basically allows, now, the original OGL, this document right here, the original OGL, this document that I'm looking at right now, which is available on their website, is very open, right? Like, it tells you what you can't touch, which is basically everything tied to Forgotten Realms or any of the major settings. But, and what you can touch is a whole lot of this SRD, which is really easy. But there isn't a lot of discussion of enforcement, right? Like, there's nothing on this that allows wizards to track who's using their license, rather than just have somebody online 24 hours a day, 7 days a week, Googling every 5 minutes for new items that might pop up on somebody's Ko-Fi or somebody's YouTube or something else. That's real expensive. Like I kid you not. In the 90s and early 2000s, remember how I showed you the trademark search? Well, big video game companies, major companies did things what we call infringement searches, which was literally have lawyers on retainer searching the internet to send cease and desist letters. The amount of man hours so many associates had to put up with to deal with that is mind-boggling. Now it's, a lot easier because it's tied to the, particularly things like the DMCA. The DMCA system on YouTube has a lot of major flaws, and I think it's really badly maintained, and I had an entire paper about why it's bad. But it makes things a lot less expensive for corporations. They can just tick boxes and let a bot run through YouTube rather than let 5 or 10 associates sit there and watch every single video that pops up on whether or not it's infringing their DMCA or not. So the fact that Wizards and Hasbro, their parent company, are creating a new version of the license to go along with their new edition, I don't care what you think. One D&D is a new edition. They just don't want to fight about the edition wars. It's a new edition. So, makes sense that they chose to create a new version of the license to go along at this moment in time. But I have concerns and questions about the license, and unfortunately, the current document that is leaked, and this is the document that is leaked, and this is the document that I am running off of as a leaked document, is not the actual license. It is merely the FRQ about the license. And that causes problems, right? Like, everything I'm saying has to be taken with a grain of salt or a caveat that this could mean something entirely different, because the terminology that's in the license, and we talked about this, right? Like, the term perpetual in the original license doesn't mean it's immortal. It just means it doesn't have a set expiration date. And if I don't know exactly what the words are or the terms that you're using, then I have concerns. Couldn't the same be said when GPL 1 was released? Oh, Unstable Dios. Yes and no, but GPL 1 is... So it gets really complicated. Software can be copyrighted, but it can't be patented. It gets complicated and fuzzy, and there's a lot of issues right now with how software is treated. So the GPL is a little bit different than something like an OGL, like the OGL is. It's... What the heck? Okay. What the heck is going on? This document. Yes, perpetual versus in perpetuity, but again, even in legalese, in perpetuity is not the same thing as immortal. Right? Perpetual means it just doesn't have an expiration date. And in perpetuity is the older version of perpetual, meaning it doesn't have an expiration date. If it did have an expiration date, it would be instated and included in this license. And since this license, as we said earlier, does not include the term irrevocable anywhere in this document, they have the right to revoke it. Now, do I think a lot of these things are good? No. Exactly. The word irrevocable exists. If it's not there, then it isn't it can't be read in. And particularly, Krellin, you are correct. Irrevocable does exist, and particularly courts don't like reading in terms to begin with. They believe in the four corners of the document. If the written word is king, if you wanted to try and get something else introduced, it only works if you're something ambiguous, and if it doesn't contradict the four corners of the document. If it contradicts anything in the four corners of the document, then you're SOL. But they particularly don't like to read in terms like irrevocable, because that has such a particular A meaning, and B is such a stringent boundary that the courts don't like to take things to extremes or read in extremity in any case. Yeah, legal documents do not make inferences. Nope, they don't. So this right now is not a legal document. It's an explanation. This new version, this leaked document, is an explanation of a legal document. It is not, however, a specific legal document. Okay, so they're saying that non-commercial is anything where you don't, if any form of payment or income for access to your work is involved or is specific to a particular work, even if it's just $1, it's covered by the OGL commercial. Okay, so now this is interesting. It is delineating between things that are specifically commercial versus non-commercial, and this is where things get fuzzy because, again, remember we talked about mechanics can't be copyright, and non-commercial gets really fuzzy. You don't really need a license for non-commercial because of the issue of fair use in fanfic and transformative work. And this goes back actually to the 4 factors of fair use, which is the purpose and character of the use, right? And this is number 1. The first factor is the purpose and character of use. If the purpose and character of your use is non-commercial, then 9 times out of 10, the court is already going to be leaning into, all right, this, if number 1, if your purpose and use of an infringing work, if you're infringing on somebody's copyrighted work and you're using their work in your thing for a non-commercial use, whether that's educational or informative or anything like that. Educational, informative, and satire kind of exist over here. Well, satire is kind of in the middle, but particularly educational, informative. If it's sitting over there and it's non-commercial, courts are already leaning into, okay, well, we're beginning to accept your fair use defense. The second factor is the nature of the copyrighted work. In this case, it's a game, which people are meant to play and interact with. And so the court might be going like, okay, so you've created this game and you're allowing people to play it. Why I can't see an infringement coming from this. 3, the substantial. Now this is the other part that people forget. The amount or substantiality of the portion used. How much of that original work are you using as infringing, right? So infringing is where it gets really an issue, is because like how much of that, I can't copy and paste the entire monster manual into a document and be like, well, it's not infringing. No, you can never get away with that. But if I take 3 or 4 individual monsters and for a non-commercial use, might be an issue, might be a thing, might be okay. And then the effect on the market, like if I'm not selling it, then I'm not impacting your market share. I'm not going to be usually referred to as issue. Now, Krellin, here's the thing. You're talking, Krellin says, Coldrick says the next section down talking about tips re-streamers is interesting. See, that's the thing. It does, this would be very interesting. Okay, so basically it's saying you either accept our commercial OGL or the non-commercial. Again, this is not the specific terms of the license, so I can't even... So Krellin says, I remember seeing something in there about cracking down on hate speech style things. Yes, that's actually that's part of the trademark, right? If you're using something, if I have a trademark or a trade dress or an image, and again, it's tied to the good faith, like, understanding of that image, and somebody infringes, even for satire purpose, is what could be called immoral and offensive, which is a very, very slidey bar, and courts slide on that. I can have the right to say, no, you may not use my product for that use. I don't like how you're using it. I think it offends people and it will cause problems for me. So that's going to come down to that issue. The most important thing about this OGL is it has to do specifically for okay, see, Crowling, or Coldrake was saying, talking about this versus tips versus streamers. This is where it's very important that we actually see the terms of the license, because if this is the OGL, no. This won't apply to streamers streaming an AP, because the OGL has never applied to streamers streaming an AP, an actual play of any sort. It has always only ever applied to published written works. Your magic items, your subclasses, your setting books, your whatever. All of that is what the OGL covers. The stream, the game, the tips, the bits, the Patreon usage for that has never been subject to the OGL. That has always been used under fan-created content, because it is. That's fan-created content, and they have an FRQ specifically for that. It's D&D fan creation policy. Fan creation policy. They have a specific policy for this. Yeah, fan content policy. Here we go. Fan content policy. You cannot require payments, surveys, downloads, subscriptions, or email registration to access your fan content. You can't sell or license your fan content to any third parties, and your fan content must be free to others, including wizards, to view, access, share, and use. So anything I make with this, with fan-created content, is their fan creation policy. Fan-created content includes fan art, videos, podcasts, blogs, websites, streaming content, and tattoos, altars to your cleric's deity, etc. Actually, that's a very broad understanding. This is the thing. I can stream my D&D game using Twitch and not be in violation of this policy, because I do not require, and this is the important point, why words are really important in the law, you can't require payments or subscriptions. However, if somebody chooses to give me money for their enjoyment on my Twitch, then it is not in violation of their fan content policy. And in fact, it can't be, because you wouldn't be able to state, well, I run games other than D&D. I also run Witcher. I also play a lot of video games. I run Blue Rose. Again, so you can't require payments. So anything you stream on this is going to be whatever. Yes, don't get rid of anything that you're looking at. This comes down to people creating, but you can commission artists for your own character artwork, because that character that you create belongs to you, regardless of the stat blocks, the description, the depiction, the ideology of that character belongs to whoever creates it. The art might belong to the artist who is creating it, but the commission issue is a one that's subject to it. But the streams, the video games, the podcasts, the everybody on YouTube talking about, how to build the ideal cleric, everybody talking on any platform about the thing, none of that is subject to the OGL and never has been. Okay? The OGL is specifically for publishing your homebrew, your adventure that you want to write, if for any reason I wanted to actually make money off of the subclass I created for a Waffle House cleric, which I'm not, because that involved 2 different IPs and I'm not that stupid. That I can just make available for free and anybody can play it if they want. That, or if I wanted to put up the Way of the Boundless Seas monk that I created for Song of Agapio's Fortune, that would be subject to either the OGL, or if I choose to publish on the DM's Guild, subject to the DM's Guild rules, which are a lot stricter than the OGL. The new OGL, they're talking about commercial versus non-commercial. Basically what they're talking about is people who create subclasses. So Jer says, so if a Twitch streamer locks their AP VODs behind subscriptions, would that violate the document you just mentioned? No, if it depends. If the VOD, which is a re-airing of something that had aired previously, is already available, then no, it might not, because it was already originally available to other people and you could click on it, you could just view it. But limiting VOD access behind a subscription paywall, that might get fuzzy, but a lot of things on Twitch are fuzzy, and Twitch's whole entire existence is fuzzy. Like, if anybody... Twitch's entire existence is very, very fuzzy in the law. So, an argument Wizards could try and argue that it's a violation of their policy if the VOD, after the original premiere, was subscription locked. That might be a violation of their policy, but it might get very fuzzy based on just the fact that it's like, well, how Twitch uses. For full disclosure, none of my VODs are locked because I don't have partner status, so nothing on my channel is going to stay that long. And everything, if you want to check anything out, or if you missed anything, you want to hang out some more, you can check out them on the YouTube. I have one of those. I posted a bunch of talking about the OGL and talking about this kind of stuff before. Wow, I count as a raider from Pirate. Tells you what I was doing. Do I still have... Oh, hi. I did. I had both Pirate and Mandy up because I support my friends. And they're cool. But you can... If you had, however, something like all of your episodes were behind a paywall to begin with, then that might violate this policy. So it's waiting for precedent? Yes, Jer. I mean... Yeah. Yeah. Look, like, at the hardcore rule, you're streaming somebody's IP, it could, there's a reason why the movies don't violate DCMA, but the games kind of get fuzzy and allowance, and, isn't this the reason why that one guy lost his case involving Zweihander because of that document? Because of this document? And again, I need a little more clarity. I don't remember what you're talking about. The Sims has gone on record to state how long something can be exclusive. Paid access violates that rule. I'd be interested to see if D&D clarify. Exactly. Like, it'd be very interesting to see if there's a limitation, if they're allowing... Again, this is not the actual license. This is somebody's FRQ. This is probably... And I'm betting that's why it got leaked, because the lawyers... Okay, look. There are a lot of people who might leak something in a corporation. None of them are going to be the lawyers. Because, well, a whistleblower might just get fired. A lawyer who does something like this will get disbarred. Like, straight up. If a lawyer was the one who released this, they would get disbarred. This is a major ethics violation. So far, yeah. Mm-hmm. Oh yeah, Zweihander, yes. Well, the creator of Zweihander tried to do a lot of things that he didn't have the right to do, and somebody called him on it. Like they should have. I just didn't remember specifically what you were talking about. Yeah, so it'll be interesting. Again, this goes back to my comment about wanting to see the actual terms of the actual license. This is probably was taken from some PR person, marketing person, was taking what the license had and was being told to write it up into plain language. And that's why this is what got released, not the actual license itself. But was it document that stopped him? Partially, but it was also somebody legitimately called him on the fact that he tried to copyright mechanics, and you can't do that. Among other things. But was it that document that allows... Oh, no. So this document that allows streaming is Wizard's document, right? Like, okay, so this goes back to my comment about all of those publishing companies that just copy and pasted the OGL. You can't license somebody else's work, and somebody else can't license your work. So this policy only applies to Wizards. Other companies might have a similar one, and I think Warhammer did, and I think Grim and Perilous did, but it also gets really fuzzy because streaming, there's a difference between streaming a video game and streaming a TTRPG, right? Like, a video game has has specific property, and while the game might be different for different people or different playthroughs, all of the content that is created through that is specifically that video game's content. A TTRPG stream, however, the rule set in the setting, like, might belong to somebody else, but the story that's created, the individual characters that are created, all of that is created by the streamers and by the people at the table. So it's a lot harder, that making an argument to say that you can't stream a story that you wrote be really difficult. Now, it's the paywall issue that might be a thing that you could argue about, and I can understand that. Exactly, it comes into the derivative work, because, and not even the derivative work, because again, going back to my point, right? The first, if you used the setting of the Forgotten Realms, if you played through one of the published adventures of Wizards of the Coast, then you're using Wizards of the Coast property. But if I'm just using the mechanics of the game Dungeons and Dragons to run a game of Dungeons and Dragons, that's not copyrightable. Because mechanics are not copyrightable. Now, my use of named spells and dealing with, Mordenkainen's, Magnificent Mansion, all of those things, that might be copyrightable, but again, that would get into derivative works, right? And me as the storyteller and my players at the table, we're creating our new story, which could be subject to copyright itself. Remembering, of course, that copyright applies immediately at the creation. You don't need to register it, although for defense of it, it really does help. The minute an artistic work is created and put into a medium where it is viewable and experienceable by other parties, then it is copyrightable. Then it is copyrighted. Whether that is a physical or digital medium. So, and again, they're going back to the same point. If you are going to use SRD content to make tabletop role-playing games and game supplements for a non-commercial basis, then non-commercial applies. Okay, again, I would really want to read this non-commercial because that's going to be questionable. If you're making content, if you're going to use the content we make available for third-party use to make tabletop role-playing games and game supplements on a commercial basis, i.e. you're selling stuff, and only want to use material from the SRD, but not other material like Forgotten Realms setting, the OGL commercial as you covered. Okay, that makes sense. It's going back between the difference between OGL and DM's Guild. And they're probably pushing more and more people to the DM's Guild because they make more money off of the DM's Guild. Remembering, of course, that anything that's published on the DM's Guild, Wizards has the right to use, if they wish, to make into their own content, and they take 50%. It's the current rules of the DM's Guild. So what are they saying here? What does the OGL commercial mean for a small creator? Again, if you want to make videos or other content and monetize it via ads, that's going to be covered under the fan content policy. Again, so that's just ads on the platform, right? Like, you can't control the ads on YouTube. You can't control the ads on Twitch. That's the one that's going to be a little bit... This phrasing might be awkward, but again, you're not requiring... Because again, this is where words are really important. You can't require payments, surveys, subscriptions, or email registration to access the fan content. You can't sell or license your fan content to any third parties. Must be free to others to view, access, and share. Okay, if it's free, then the ad is not my fault. The content is free. The ad is supplemental. Yeah, because a lot of people are talking about things like content creators like WebDM or anybody, you know, the guys over at oh, I'm blanking on them. Or any, you know, any of the major, any of those kind of people who are making things on who are making particular videos about D&D and explaining D&D. And a lot of other companies count a monetized stream as commercial because you can earn while using it. Yeah, but at the same time, you can't, because that's where you get... They can't actually require that yet, because it gets, again, this goes into the it depends, and it gets really fuzzy. Nerdarchy, thank you, Hawkeye. That's what I was thinking about. I was thinking about the guys over at Nerdarchy, who are some good peoples. Why did I blank on their name? Hashtag not sponsored. And that's the important point, right? A monetized stream has very particular... A monetized stream and the definition of commercial aren't going to be the same, because commercial is going to mean sponsored according to certain regulations that currently exist according to the federal government. Monetization is not the same thing as commercialization. So, again, I want to read... I'm not liking it. I don't think it's great. I think might be cause for some concern here. But I really want to see the actual terms, because again, the OGL is only going to apply, only is ever applied to published works. That's not streams, that's not APs, that's not podcasts, that's not your Jim, welcome in raiders, how you doing? I am your friendly neighborhood Prax. Welcome to the channel. I use she her pronouns. We are looking at some of the wonderful rules for the new OGL. We are looking at the leaked document right now. Hello Hannah, hello Jim, how we doing? Hello, thank you for that follow, welcome in. How was Don't Rest Your Head, Jim? Was it suitably frightening? Wait, what happened? Why did that not work? Oh, I guess the better... yes, the artist is here, by the way. Hannah did the wonderful, beautiful art that we see on our Witcher TTRPG stream. If you don't know, you can check out all the YouTube VODs. I have one of those. It's right there. Welcome in, welcome in, welcome in. Hope you had a lot of fun over on your stream. We are talking about the OGL, the original OGL, what it covers, what it doesn't, other things, ownership, licensing, all of this, and looking at the leaked document, which again, as I've said multiple times, is not the actual license, it's an FRQ about the license, which is really concerning, because it's somebody's explanation. This is the document right here. Now again, I have 3 caveats that go with this. Number 1, this is the leaked document. I cannot prove its provenance. Number 2, this was not sent to me specifically by anybody at Wizards of the Coast or Hasbro or anybody like that. This was given to me by a third party through multiple steps, so I don't know its validity. But number 3, this is not a license. This is an explanation of a license, which is also a problem, because that could mean different things to different people. And doesn't actually include the legal terms. It's somebody's explanation of what they believe the legal terms mean. Who is probably not a lawyer, there could be a problem. So right now, one of the first things to remember is that right now it's still reusing the concept that the OGL is only applying to written things like homebrew, settings, stat blocks, subclasses, which is what the OGL only really applies to now. It's separating out commercial and non-commercial, which is interesting. For most of the community's content creators, those making under $750,000 per year in SRD-based content, the OGL... Okay, so it's $750 a year in SRD content, right? It's not somebody who makes $750,000 a year in content, and that's not your gross in general. That's just your OGL gross. That's a little different, right? Like some people, that would be Cobalt, you know, some of the big names like Cobalt and Paizo, that would be the everything. But for most of us, we're not mooking that. The commercial change is very literal and is primarily designed to help us know you better. Okay, so this statement right here. Remember how we talked about, for those of you who are just coming in, welcome in. We were talking about there's this concept in IP law that you have the right to license things and make money off of your intellectual property, but at the same time you have responsibilities, and one of those responsibilities is policing your property, paying attention to it and knowing how it's used, how it's licensed, and who's using it. And I bet you this is part of that. I bet you this is part of that. They're looking at the original OGL, and it's been 20 years since the original OGL, and there might be some concerns about, you know, how close are you getting to that issue of what we called naked licensing, where you haven't been policing your license at all, and therefore are at risk of losing that protections. That's a question. Under the OGL, those creators will need to register their commercial content with us so we know what's out there. Tell us a bit about their products and product sales, and start adding to a creator product badge to the materials so that everyone in the community knows they're publishing under the OGL. Okay, so this part, the creator product badge, is tied to very similar to the original OGL, which basically states you have to include this statement. You know, you have to include the license in whatever you publish. That's already part of the OGL. So a creator content badge, okay, that kind of makes sense. Telling them, I don't know how they're going to do that. I don't know how they're going to monitor that. I'm assuming it's going to be some sort of form that they're going to make you fill out. I'm assuming. And then I'm also assuming that it's not going to, given just the sheer number of creators, that they weren't expecting actual people to read that form, but we're going to have some sort of filtration system that was going to be automated, because everything is. So here's the statement. It wasn't intended to subsidize major competitors, especially now that PDF is by far the most common form of distribution. This is a play at Paizo. Maybe a little bit of a play at Critical Role. Given the amount of money they're making. If they link the image, they can associate the IPs with specific content creators. Exactly. Like if they've got a creator badge, then they're basically saying, okay, this is going to be the trademark that goes on what we call third-party material, and it therefore is now lesser, and we don't have to worry about them using our trademark and affiliating things that we don't like with that trademark. But yeah, this statement right here, it wasn't intended to subsidize major competitors. That's a play at Paizo. Oh yeah, and Critical Role. It's got two of them are a little. Well, that's the thing is Critical Role's books that are with WotC are already covered. And I don't think people are saying that it's probably, you're correct. I should backtrack and restate. You are correct. I don't believe that it's about Critical Role, because I firmly believe that given the fact that they had already published with WotC before, everything Critical Role does, they have their own independent license. I bet you they're not operating under the OGL. They've already got a private license. They're like Roll20 or D&D Beyond before they got bought. They had an individual license and they weren't operating under the OGL. Yeah, the individual story is their own. The Exandria setting belongs to Matt Mercer as the creator of the setting. Maybe some also attribution to the other two DMs who's played in the Critical Role Expanded Universe, whose name I'm blanking on at the moment. Abria and Brendan. Yeah, I'm based on what they've done and what they've gone through with the video. I'm almost 100% sure that Critical Role already has their own independent license. That's not really part of the. They wouldn't be operating under the OGL. Paizo's still operating under the OGL. This would definitely be play at. Yeah, it depends. It really depends. So moving forward, hugely successful businesses that generate more than $750,000 of annual revenue will need to share some of that success with us by paying a royalty of 20 to 25%. Okay, that's not horrible, but that's a big number. They make in excess of 20. Okay, see, look, they're of the qualifying revenue, they make in excess of $750,000. All right, so This is where me being a lawyer brain means I can read things into this document and make assumptions. But again, my next statement is an assumption. It's probably not 100% accurate because I don't have the actual terms of the license in front of me. But this is where it says, so because they quoted the qualifying revenue means that you only are going to have to pay 20 to 25% of the revenue that you make in excess of that $750,000. So if you make $750,000, $780,000, you're only paying the 20 to 25% of the $30,000 you're making in excess of the $750,000. It's probably going to be gross. That's the other question. Is it gross or net? It's probably going to be gross because of that's how reporting is done. Now, most major publishers already have this kind of licensing agreement and royalty agreement in case. The uniqueness about this is the fact that usually those royalties are based on privately negotiated licenses that both parties have the opportunity to sit down at a negotiating table and make adjustments to and discuss the actual numbers involved. The fact that they're putting that number on the OGL, I'm pretty sure this is to push people who make that number to not use the OGL at all and make independent licenses with them. And depending on their business model, it might be significantly less qualifying revenue. Exactly, right? Like, that could be a thing. See, that's the other thing. I'm betting this is it's not good. Do not get me wrong. But my reading of this, and again, going back to our previous statement that we started at the beginning of the stream, you can ask 5 lawyers their opinion on this document and you'll get 8 answers. Because it depends is really a big deal. But I'm betting, because the next paragraph they put in there is, how do I agree to the OGL commercial? Anyone publishing the content under this commercial license will need to register the content with us by creating an account on D&D Beyond. Ooh, there we go. Providing us with identifying information such as the name of the person in the creating work, title of the work, a summary of the work, and once the work is available to others, a copy of the work. Well, yes, that actually, all of this so far, this is not a surprise to anyone who actually does licensing. Like, this is not a surprise. When you complete the registration, you'll also be confirming your agreement to the terms of the OGL. Yeah. By using this license, goes back to what they already have in the other one. By using the open game license, you indicate your acceptance of the terms of the license. Yeah, Hawkeye. Hey, buddy, you want a better deal? Get one of our licenses and avoid the OGL. Exactly. I think, what if I don't like these terms and don't agree with the commercial? That's fine. It just means you can't earn any income from any SRD-based D&D content that you create on or after January 13th, 2023. This date, by the way, is probably going to go away because we have not seen an official announcement of this document, and therefore, this date, they can't get away with this so early. Like, there's no way this date is going to be backtrackable, or because this document is not officially released, this date is going to be changed. And you'll need to either operate under the new OGL non-commercial or strike a custom deal direct with Wizards of the Coast for your project. There you go. That's what it is. This is, my reading of this is to force people who make a certain amount of money to make a private licensing agreement with Wizards of the Coast. Now, will it be better than this 20 to 25%? Probably. Will it be necessarily free? God, no. They're still going to have to pay a royalty. Royalties are not, again, a royalty is not a surprise here, right? the fact that people got away without paying royalties for so long. The fact that Paizo exists without paying a royalty is a big thing. So what's required to build a legally distinct game like D&D, which is truly open? So that's a complicated question. Unstable Dios is asking, and the complexity of the question comes down to the fact that, number one, the mechanics are not copyrightable. So I could go out and write a game based on rolling a d20 and adding or subtracting a modifier based on a set of skills and stats, even calling those skills and stats strength, charisma, wisdom, intelligence, agility or dexterity, and strength, dex, constitution. I was like, what the heck is the last one? And that would be entirely fair. The expression and how I write that statement, unless it is considered the only acceptable way to write that statement, would be protected. And that's where you're going to run into issues. And if you want to make it truly open, then you need to create your license on your game that basically says, hi, I don't care about my copyright. You can do whatever the fuck you want with it. Or use the Creative Commons BBY license. But even then, it's not as open as people think. So. But you could go and write a game using a D20 system talking about elves and dwarves. You probably couldn't use gnolls or, certain other races. Species, really, because they are species. But some of them you could, because you would just have to change the names. It'd be the terms that you use for those particular species, right? Like, an anthropomorphized rabbit, 6-foot-tall rabbit, predates D&D significantly. Hi, go look up the Irish mythology of a puka. Yeah, exactly. Mind flayers, illithids, beholders, anything that you get on mimic as defined by D&D, that would be questionable, and I believe is their own. Exactly. Go ask Harvey. Good movie, by the way. It is... See, the thing is, a lot of people like using these short... Okay. The reason people publish and use the OGL and the DMs Guild is because, how to phrase this? Because there is the reason why anyone would want to purchase a licensed material, because there's already an existing audience, right? Like, there exists an audience out there for Dungeons and Dragons who might be willing to buy your adventure, your homebrew stat block, your very fond of rum pots and crackpots. And how are you, Mr. Wilson? I'm doing quite well, thank you. But there already exists an audience out there that might be willing to buy your product. If you have to create a new game, there is no good faith tied to that product yet, and you have to encourage people to go buy it. Speaking of which, hi, you might notice a panel directly below my face that says, would you want to tell your own stories? I write games. I publish them on itch. Would you like to go see them? Full disclosure, I don't make a lot of money from that. A lot of people don't buy into those because it isn't selling D&D. It isn't selling an established property. And therefore, it's a lot harder to get people to buy them. But you can mythologies you can use, hopefully respectfully and understanding the fact that, you know, a Kirin is has a very particular meaning in Chinese mythology and Chinese literature, and not just do something weird with it. Or Anasazi or anything else. But I have been working on a game for a while that kind of took a backseat to the fact that I'd been going to law school and spending a lot of time doing IP law. Specifically about the summer and the winter court of the Fae and using Irish mythology and a lot of Welsh gods, particularly, actually, and the definitions of Fae in that concept. And all of that is entirely fair, and I can do that. Because all of that's public domain. I cannot use I can't use Wizards of the Coast's description of Asmodeus, even if I use the term Asmodeus and him as a Prince of Hell. Oh, Fae game probably sometime after I take the bar in July will be a thing, and I will probably be streaming it on this channel. But it is now 10 minutes to 12. We have some more work to... I want to look at a couple more pieces of the released leaked document. I want to talk a little bit more about a couple pieces of it in particular. Would you need your own unique description? Yes. Yes. Even if I talked about tieflings or demons, I would need my own unique description or expression. Again, mechanics, not copyrightable. Expression, copyrightable. Unless, of course, you are providing something where the only... How close to the bar before you go completely silent? I will not be existing after after Memorial Day. And if I do, it'll be pop-up video game streams. Maybe Mechton, depending on what I believe I can actually function or not, because it's a lot of fun. But I think this is a good place to take a break. I need to stretch, get some water. We'll come back. We'll probably go for another couple hours or so. I want to look at a couple other points that I highlighted in the leaked document that I want to talk about. And if you guys have any questions, go ahead and put them in the chat. You can check out that. Also, if you're new here, you might notice that there's a new button below on the panels. There's a new button on the panels. Just that new button goes to a new thing that I decided to do, where I have a merch store now that you can go to. And you can look at things. You might even find the link in chat. Just saying. Yeah. There are people who are like that who would never come out, and I will probably be mostly like that. I might also need people. But yes, I'm gonna go take a break, short break, five-ish minutes, get some water, stretch, do all of those things, and I'll see you in a little bit, everybody. Hello everyone, welcome back. Hope you stretched, refreshed, bio, did all of those good things. I got some water because I really needed that. But we're continuing our discussion about the OGL and all of those things. And the leaked document, again, prefacing this with the statement that this is a leaked document, I cannot prove its provenance. It was not given to me by anyone at Wizards of the Coast in any way, shape, or form, or by their parent company, Hasbro. It was a document that was given to me by a third party, and there are some things in this, y'all. So we talked about the fact that it's not the license, it's an FRQ about the license. It's separating out commercial from non-commercial. It's including this right here is something that is actually kind of important, right? For example, when we released OGL 1.0a, YouTube apps, blockchain, crowdfunding, and other now everyday technologies and distribution channels didn't really exist the way they do today. Also true, most of them didn't exist at all. The OGL wasn't intended to fund major competitors, and it wasn't intended to allow people to make D&D apps, videos, or anything other than printed or printable materials for use while gaming. All of this is true, and in fact, but it's not specifically stated in the original document. It was covered under fan content policy, but not under this particular document. So updating the OGL to cover these things and specifically state that the OGL is only designed for printed materials, well, that makes sense. Right? It's like that's what the OGL is for. Other licenses cover other things. Additionally, over time, the old LGL incorporated some confusing and even contradictory provisions. Not really. The provisions are really kind of straightforward. And was also written in fairly dense legal language. Okay, y'all. Is this dense legal language? I mean, I have to ask this question legitimately because I am now at a point where I read so much law that I don't think this is dense, right? I think specifically that there are terms in it that are very defined by important issues with the law, and that they're all very important here, that are very distinct, like the term perpetual, and have distinct legal meanings, but I don't think that it's dense. So while we're updating it to take in... Yeah, exactly. Like, I don't think it's dense. I've read much denser stuff. Like, go read your insurance policy. That's probably a whole lot denser than this. Any TOS is denser than this. Containing legal language isn't the same thing as being dense. Okay. Yeah, your home contract is dense. Okay, so now they include the non-commercial, the commercial... Okay. Yeah, Dune is denser than... Look, the only thing denser than Dune is Les Mis. Literally. Who can I contact if I don't understand something or need help? No. Okay, this statement right here? No. Do not do this. I do not care. This statement right here, who can I contact if I don't understand something or need help? If you have any questions about what you've read in the OGL non-commercial or the OGL commercial, please reach out to us at before using or signing either part. No. Just don't. If you don't understand it, go to your own lawyer. Do not reach out to the other party of a contract to get to understanding without reaching out to, oh wait, your lawyer first. a conflict of interest. Okay, so now we've got this, and I think, okay, so this is the links that they aren't active, and then I guess this is the... This is the license. Yeah, this third-party arbitration. Don't... If you do not understand the terms of this license, get your own attorney to read it. And ideally, and here's the thing. Well, this is me getting on my soapbox a little bit. Well, one individual person publishing just a random thing and throwing it up on the DMs Guild or on DriveThruRPG or having a random thing, individual thing, could just read the OGL and be like, all right, I'm going to publish something. But if you have created a company, whether that's one person or 20 people, you should have your own attorneys who should read everything about this before you touch it. If you have a corporation, you have an attorney. Call your attorney, have them research. And AnnieGeek, you have to wait until after October for me to be hired. That's pretty much the standard. You take the bar in July and you hear it by October. Yeah, no... If this was an in-house document, the contract info might be their lawyer. Exactly. They're like, don't contact someone else's attorney. Don't contact the other party's attorney for information about a contract that you want to discuss terms or understand terms about. That's a conflict of interest. A, they can't help you, and just don't. Nah. Okay, so any non-commercial use of licensed contract is subject... Okay, now see here, this is the part where we begin getting into the license, but then they got comments into it, right? Like, comments are weird, and usually... It's a little weird. Not abnormal and not unheard of, but a little weird. And again, see, they're providing definitions. We is the Wizards of the Coast, you are the creator. Usable content, which is now defined as the licensed content. Non-usable content, all is undefined content. See, here, this is where we go back and say that if you had left, you would have been in a better place if you had just left the whole section of definitions at the beginning. Which is why I'm almost positive this is not the final draft of this. There would usually be just a whole section of definitions, and I don't see that here. Okay, so it's creating the same defining the product identity. Unlicensed content is not covered by this agreement, and you agree not to use the unlicensed content. Again, the same thing about using the DMs Guild. So right now, this is all pretty straightforward. Going to the same issues, this is all straightforward. Printed media and static electronic file formats does not apply to anything including but not limited to things like videos, virtual tabletops, VTT campaigns, computer games, novels, apps, graphic novels, works, music, songs, dances, and pantomimes. None of that would have been covered by the OGL to begin with. You may engage in these activities only to the extent allowed under the Wizards of the Coast fan content policy or separately agreed to between you and us. And again, all of this goes back to the concept of the fact about what they can copyright and what they cannot copyright and how that would work. Licensed work for work to be licensed work under the OGL must meet all the following qualifies covered work as defined by section 1B. Okay, so they are creating... All right. If and only if you fully comply with the terms and conditions of this agreement, you may copy, use, modify, or distribute licensed content around the world as part of the licensed work on a non-commercial basis, meaning for free, not in exchange for money or any other thing of value. Ooh, that might be difficult. That would be complicated, and that phrasing right there, that would be complicated. Because now that's basically saying things like artist exchanges, not artist artwork, because that wouldn't be included under the OGL to begin with, but not things like artist exchanges for things like stat blocks, or if you're sharing adventures back and forth, are those you are ascribing value to? The anything of value is problematic here. I have concerns about that. We may offer others the ability to use licensed content under any conditions we choose. Okay, so that's under any conditions we choose. This is very vague. Value is too vague a term for this document, because the courts have consistently held that okay, so there's a dichotomy that the courts kind of exist in, right? A contract for no value, how to phrase this? A contract for something that that doesn't really include a value is not a valid contract. However, by the same token, they don't really get into what is ascribed as a acceptable value for something, because what one person might be willing to pay for a thing, someone else might not be. And what the value of an item is ascribed by the person, what a person is willing to pay for it. It's the ball that Mickey, if somebody's got Aaron Judge's 60-second home run ball and wanted to sell that, now is the value of that ball $7, which is the cost of what the Major League Baseball company buys the actual just ball for? Or is it the $5 million if you can get for somebody to say it's the, Aaron Judge's 60-second home run? The court isn't going to be like, hey, that $5 million is a really, really expensive amount of money for that particular small baseball. But at the same time, if there's something that's obviously unconscionable, or if there's no value in the exchange, or the value is entirely disproportionate, they might say that it's not conscionable, and therefore you didn't actually have what is called consideration. You may not actually want to make a bargain, make a deal, make a contract. So the term value here is very amorphous. Like, how are you defining value? How you can't say you can't give you're saying you cannot do it for money. Fine. But what are you saying then has value? I think that's a very problematic issue. That's the first red flag I see. You may not transfer your rights and duties under this agreement under any circumstances. Okay, so basically it's saying that this license is not sublicensable. That's not actually a surprise. Including that is not a surprise. Let's put it that way. I'm kind of glad that makes sense. Said intro, commercial distribution is any distribution you get paid for in any form. Money, crypto, barter. This is where we get issues. Barter. They're including barter. Your brother doing your chores for a week. Whatever. Okay. Does not include donations people give you to support your work, as long as they can access your work for free if they choose to, and you informed them of that in a clear and obvious way. Okay. So if I said, hi, I have an adventure on the DMs Guild. It is, or you can watch my stream, or you can, if I wrote something like a setting book and put it up on the words in my head, if I wrote a setting for D&D and put it up on my Ko-Fi, hi, I have one of those, and made it available to everybody with no, and didn't put it behind a paywall, or didn't require payment for it, then it's fine. But the minute I put it behind the paywall, like, I can still accept money for it, but I can't require money for it. Okay, but that leads into the question of, how are you defining barter? Okay, so you have to identify what your license, what part of your content is licensed, and you have to allow for that distinction. Like, you have to showcase that what is licensed and what is not. And yeah, the citing to the SRD is actually already included in the original license when it gives you the SRD page number system. Okay. Letting you use licensed content for free because you're using it on a non-commercial basis. If you want to better protect your ownership, you may register it under the OGL commercial if you agree that others can do the same with your work. So basically, they're forcing you into a Creative Commons license by saying if you create anything under this, anyone is allowed to use it because it is for non-commercial purposes. Which, that's not good. They're forcibly saying that your content is now also not protectable, and anyone could use anything you create under the non-commercial would not be protectable under your own copyright, which, even if it doesn't, if you leave off the stuff that's not, if it's yours, it's your creation, it's your words and the stuff that isn't theirs. I don't know, that gets really fuzzy. I think that's a major concern. I would have concerns about that. I have concerns about that. Yeah, Antigeek says, I feel like barter might mean you will give someone exclusive access to something in exchange for something exclusive access to something of theirs. Yeah, but their comment really changes that by saying, what is the line? Barter. Your brother doing your chores for a week in exchange for you writing him something. Okay, but then what about things like art exchanges? Or, which have consistently been viewed by, as not the same thing. Yeah, I'd have to see. Okay, so if we go forward, if we scroll forward, so, donations, your distribution of your work must be non-commercial. This means you cannot require that anyone give you anything of value for your work or copies of your work. However, you are permitted to accept donation through Patreon, Ko-Fi, and other similar platforms. Good, you can't stop me from it, but I can't put it behind a paywall. Fine. So I can't put any, if I'm on Patreon, I can't put any Patreon exclusive content on. I can't put any Ko-Fi subscriber content on. Oh, they're talking about both crypto and NFTs here. Yeah, oh good. You acknowledge the fact that you have to be over the age of 18. This agreement may be modified or terminated. They're throwing that clause in exactly, much more clearly than it is stated in Section 9 of the original, but the same concept that they can be changed. an update to the, see, this is how they're doing it. This is an update to the previously available SRD, OGL, which is no longer an authorized license agreement. There you go. By saying that one sentence, they've covered themselves for anybody who comes back and says, well, the OGL, you can't revoke the OGL. Yeah, they can. They're not revoking, they're modifying it based on existing terminology. Okay, they can terminate, being very clear. You breach any other term of this condition. You bring an action challenging our ownership of the licensed content, unlicensed content, or a patent or trademark. This is problematic. But at the same time, not 100% wrong. Like, if you are a licensee for a patent, you are stopped from challenging the licensor. Yes, for patents, and I believe for trademarks as well. If you're the licensee, the person who has been given the license, you are stopped from challenging. This is where it gets funny. You are stopped from challenging the validity of the licensed content after you sign the agreement to license the content, because under the court's understanding, by accepting the license, you're acknowledging that the person had a right to license that document. If you want to challenge them, you have to challenge them before you use the license. So basically, if you want to challenge this, don't create anything under the OGL, and then you can challenge them. Also, I would assume, based on the way this is written, don't put anything up on DM's Guild, because that would also be ascribing to the same content. It's kind of like... You can't challenge their ownership of the thing by accepting the agreement and then saying, well, no, they don't actually own that. It's better. Oh, you have to tell them that you're providing written notice that you're terminating the agreement. That's interesting. We know that but it's important. If you attempt to use the OGL as a basis to release blatantly racist, sexist, homophobic, transphobic, bigoted, or other discriminatory content, do anything we think triggers these provisions. Now, this isn't wrong. This goes back to the very famous discussion about, pornography it's really hard to find, but I'll know it when I see it. This is definitely if we find it, if we don't agree with something and we think it triggers any of these provisions, that content is no longer licensed. You waive the right to sue over our decision on these issues. Oh, that's a great statement right there. That's not enforceable. That's a problem. We are aware that if we somehow stretch our decision of what is or is not objectionable under these clauses too far, we will receive community pushback and bad PR, and we are more than open to being convinced that we made the wrong decision. That doesn't sound right. But nobody gets to use the threat of a lawsuit as part of the attempt to convince us of... Oh. Yeah, so this is definitely a draft. Right? Like, this isn't even formatted correctly. You can't be forced to waive your right to sue. You can be forced to agree to arbitration. Yeah, it's this I don't know what draft this is, because there are some very obvious things that I would say your lawyer is going to say, no, you can't say that. Now, admittedly, clients can ignore their lawyers, and corporate clients do it frequently. Okay. This might not be true. Gets a little fuzzy. You're only obligated to pay royalties on a license as long as you own the license, as long as you are utilizing and using the license. The minute the license is terminated, the minute the license is terminated, you may not use the licensed content to create anything, but by the same token, you aren't responsible for royalties unless they're back royalties that you should, and usually somebody will have to sue for those. Although you're still legally responsible for like royalties that you were supposed to pay and you didn't. But the minute the license is terminated, you can't continue to use the license and they can't continue to collect royalties from you. Oh, they're talking about indemnifying. Okay. No, Wow, I did not think that is correct. If we are on the receiving end of any legal claims, fees, expenses, or penalties related to your licensed works, you're responsible for paying all of our costs, including attorney's fees, court costs, and any judgments or settlements. Not if I'm not a named party to the suit. I'm not. Good luck. Now, if somebody say that they wanted to sue a third, here's the thing, this would never be how this works. You would sue the third party creator, and the third party and I would assume then that you're naming the Hasbro and Wizards of the Coast as the deep pocket against the third party creator. But the court is not gonna you don't need to indemnify, because the court is not gonna accept the claim unless you can prove that there's a legal reason to name the other party. Like, there isn't. This claim would get thrown out. Co-owner means co-responsibility. Yes, but they're technically not co-owners in this case. The DM's Guild, they're co-owners, and you could contributory responsibility is a thing, and you can delineate how much or how little somebody is responsible for harm in a tort case. In this particular instance, I'm trying to figure out where the legal claim would be against a third party that wouldn't include of a licensed material that. So, for example, like, because of this is all about the D&D, right? It's all about the products, the homebrew, the stat blocks, the subclasses, the settings, all of that. I'm trying to figure out a way in time in which somebody could make a claim against both the third-party creator of their own individual content and Wizards of the Coast that would survive a 12b6 motion to dismiss on the claims against Wizards of the Coast, that did not specifically address content that was already there. You know, like, I can't see a way in which you would be suing. This doesn't mean that I'm, you know, I don't understand this. Like, it, because of the way the licensing works, so here's where my struggle is. If I have a patent license, right? And I'm going to bring it back, and I'll come back to your point, Dragonicore. See, the problem with that, Dragonicore, is your argument is, what if someone wrote a hateful or bigoted piece that got approved by the DMs Guild, if they're both owners? But that's the thing. This isn't the DMs Guild. This is the OGL. So anything that published on the DMs Guild isn't covered by the OGL. It has its own agreements, which are actually more stringent, and hey, Wizards takes 50% off the top of everybody, regardless of thing. So this would be basically saying, okay, here's the comparison. I am a licensor. I have a patent for a machine that makes beer, that bottles beer, right? And I license this machine that bottles beer to, you know, to Coors, right? And something goes wrong with the machine, and there is a cause for somebody to sue both Coors and I for the machine's malfunction because somebody got hurt. Right, that's the thing, is like, there has to be a harm for a lawsuit to exist. Whether that harm is physical or metaphysical is complex, but yeah, like, if I am the person who patented the thing, and the only way I could prove in a court of law that the case would go forward and I would continue against the suit and require to be indemnified against the suit would be if the court, like, here's the thing, if the person got hurt and I am a named party in the suit, then I'm a named party in the suit because my machine is inherently bad. And it wasn't just user error, the machine was bad. Right? Because if I can say that it was user error, if Coors installed it wrong, or the person, you know, they changed something about my machine that wasn't included in the license, then I'm not legally responsible. And I cannot think of a way in which the content that is covered by the OGL and the way the OGL works, you could bring a suit against Wizards of the Coast, for which would be, you could only sue them for the licensed content, right? You can't sue them for your content, the content that would be objectionable or racist or homophobic or any of that, which you still have the issue of that whole issue may not even survive an original 12b6 because the First Amendment is a thing, and whether or not we like it, that means that a lot of these things are protected. It's a horrible thing, but yeah, exactly. It's a question of the failure to correctly maintain versus a failure of the machine's design, or it can be indeed a combination of those, and that would be a point in which both parties would be liable. But this, because of what the SR, you know, because of what you're licensing, the only way that you would get a lawsuit, honest to God, the only way I could see a lawsuit coming out of this effectively, and this is my predication. Effectively, lawyers will try to encourage you or to sue for anything, and a large number of people out there will sue at the drop of the hat. But that doesn't mean that it will survive claims or pleadings, and by that I mean you have to file a document with the court that you have grounds to recover, that you were actually harmed under the laws that exist within that jurisdiction, whether it's state or federal. And if you do not have, in the defense, the first motion that 99% of defenses are going to file is a 12b6 motion. Rule 12b6 of the Rules of Federal Civil Procedure is you're making a claim on which there is a failure that there's no claim here. Basically, my defense is you can't sue me. You have no reason, you have no claims with which you can recover financially or even equitably. There's no case here, is my argument. So I'm trying to figure out a way in which, now I'm also tired, but I cannot think of a case in which, in the case of Dungeons and Dragons and the licensed content of the OGL, you would name Wizards of the Coast as a party to the lawsuit, along with a third party, and not have it be either immediately severable, i.e., Wizards turns around and goes, I have no tie to this content, it is not my fault, and moves for 12b6 and gets themselves out of the case, or B, it's actually about Wizards content, in which case you can't indemnify somebody about your own content. So I'm very if this is claiming, if on the receiving end of any legal claims, like I'm responsible for your 12b6 motion, that's very strange and usually not how licensing agreement works, to my knowledge. Like, usually if that's not how a licensing lawsuit would work. The only way Wizards would be named in the claim to begin with is if they're claiming against Wizards content. And in which case, then they're just bringing in Wizards content as a named issue. I'm very concerned about this. If a claim is raised against you in connection with a licensed work and you aren't defending such a claim to our satisfaction, we have the right but not the obligation to take over. Oh, no. Okay, so this whole paragraph right here, these 3 paragraphs right here, are taken from your insurance policy. Basically, your insurance company, if for say you are sued for something, most homeowners can turn to their insurance policy to begin getting, to have the insurance policy indemnify them and pay for their legal fees. It's part of your homeowner's insurance. It might also be part of your renter's insurance. It gets a little fuzzy, but it's a thing about insurance. And the argument about there's an expectation that you are an active and willing participant in your defense, even if the insurance company is the one who's paying for that lawyer. I have never seen this phrase. This is a now admittedly I don't do a lot of major business law, but I've looked at a lot of things and like, okay, let's take for example a car, right? There's a car accident and the person claims that the brake pads on their brand new Audi were faulty. And so they sue both Audi and the brake pad manufacturer. Then again, it's not a licensed work. Go back to our patent issue, right? It's about the patent issue. So I have a license I own the patent on this machine, and I license it, and I am the owner of this beer filling machine, and I feel that Coors is not actively defending the claim to my satisfaction, and I am not party to the litigation, I can take over the defense in the litigation and then force the licensee to pay, and then force Coors to pay for the expense of that litigation? I honest to God, I've never seen that. I do not know how valid that claim this one is. This, however, this is actually not uncommon. Yeah, I don't like the sound of that. If you don't like, you're not party to the litigation, you're not a named party. Nobody has brought you into this litigation, but you feel that I am not defending it to your satisfaction. You're going to take over the litigation and then force me to pay you for it? That's if you're not a named party in the litigation and you're not brought into the litigation, you have no standing. Right? Like, the insurance company becomes a party to the litigation when you turn to them and ask for, use your homeowner's insurance policy or your, corporate CEO insurance or your whatever insurance policy to pay for the litigation. So it will never be they may or may not become a named party in the litigation, but they will be tied to it because they're paying for your defense. But if I am not a named party in the litigation, and I'm just look, if I'm sitting here watching from the outside, and there's this accident, right, at Coors with my beer filling machine, and I'm watching from the outside, no one is suing me. I'm not a party to the litigation, but I'm watching Coors and going, you're not actively defending my machine well enough. I don't like the way you're not defending my machine. And as part of our licensing agreement, I can come in and take over this litigation and force you to pay for it. Yeah, I'm not sure that would fly. Now, with your insurance policy, there's usually something about the case like, we will provide an attorney for you, or if you choose to use your own attorney, we will pay, but only as much as we would pay for an attorney. Usually a set amount equal to the amount of money they would have paid for the attorney that they would have provided. However, the flip side of that is that the insured, the person who's using the insurance company to pay for their insurance policy to pay for the litigation, has the right, the attorney has to make the decisions because the claimant, okay, see, here's where this is the other issue about this. We have the right but not the obligation to take over the defense claim against you. Here's the thing. If they're not a named party to the litigation, then you, the creator, are still the named party to the litigation. You are the client. It doesn't matter who's actively paying the lawyer. The client is the named party on the litigation, and the lawyer has the responsibility to provide the best service to the client. It's an ethics issue. I have some real issues with this whole B. This one bothers me. This one, C, this is more common. This is also a thing in insurance cases. We may at our discretion seek to intervene in a case brought against you in order to join in the defense of the claims while leaving you and your legal counsel of your own in charge of your own defense, right? Like, this goes back to my comparison about the beer filling machine, right? It's like Coors is being sued. I'm not a named party in the defense, but I'm watching this case and going, okay, they're going to start talking about the machine, and if I bring myself in as a named party and could join as a joint defendant in this case, if the court allows me to, because some courts won't, if I don't have standing. In this case, you probably would have standing. But, like, if I join, then I am still my own client and have my own legal responsibilities, and Coors is still their own client with their own interests and their legal responsibilities, and their attorney is going to be their own issue. But this, we have the right to take over your defense and then force you to pay for it. I have never heard of that. I have honestly never heard of that. So, well then, moving on. Wow. Okay, so they even include the statement. As for our own IP, that's ours to defend. You don't have any obligation to defend Dungeons & Dragons IP yourself, and in fact wouldn't have standing the legal right to do so. So how are you going to become party if a claim against you is raised against you in connection with a licensed work? Okay, so maybe it's only about what's being licensed, but then that goes back to the point of why are you not naming wizards in a license if you know that the product is licensed? Look, the first thing I would do, and this is where a lawyer would be a thing, and you talk to your lawyer if you ever get sued. The minute you get sued, or even if you think you might possibly be sued in the near future, actually, that's the more important one. If you think you might be sued in the near future, for whatever reason, talk to an attorney immediately. That directly applies to the SRD, correct? Exactly. Like, so anything that is their IP, which includes the licensed content, is your IP and therefore your legal right to defend. If you're suing over the legal licensed work, like, if I'm getting a lawsuit over the connection to a licensed work, I'm gonna turn around and say I don't have standing, it's a licensing issue, you have to take it up with a licensor. That's what you're telling me here to do here. Like, this whole section does not make sense. Ooh, promoting something that is substantially similar to a licensed work? Okay. So basically you're using the definition of the licensed work is something that contains any of your licensed content. So this would be like, okay, you created a module that harmed someone and isn't just... Or you're being sued for infringement, right? Like, that's the only other way it would work. You'd have to be sued for infringement. That your licensed work is an infringing work on somebody else, which isn't for, which is not like, it includes some sort of infringement of something else, and and Wizards is brought into it, but then it's still, I still struggle with that. Like, I still struggle with this whole thing. I don't. You own the new and original content you create. You agree to give us a non-exclusive, perpetual, irrevocable, worldwide sublet. No! This is a straight no. Like, straight up. This clause right here. This clause right here. If this clause is really what's included, I would not publish under anything for D&D. If the final version of this license includes this clause, I would not publish it. This is worse than the DM's Guild. This is acknowledging that I own a thing and that I am giving them. Now, the only thing that makes this... No, it's still... No. This is still a problem, because the only thing that makes this almost okay is the non-exclusive, which I think is the reason they threw it in there, thinking that, hey, if we throw this this statement about being non-exclusive... No, you still own it. You still own it. They're not refuting your right to own or that it is your property. And because it's non-exclusive, you could theoretically license it to someone else. But the fact that it is immediately a perpetual, again, remembering that perpetual means there is no expiration date. And then this word right here, irrevocable, worldwide sub-licensable, meaning that they can license it themselves to someone else, royalty-free license to use that content for any purpose. No, it's you own it, but you have no rights to it. And you can't stop us from doing anything we want with it. Well, that's not true. You do have one right. Your right to let someone else use it. But we can use it immediately, do anything we want with it. Oh, and hey, we can sub-license it to anyone we want, and that doesn't include any royalties for you. And we don't have to pay any I guarantee you that this is a this is a straight up no. Like, if this is included in the final version of this document, I would not publish anything for Wizards of the Coast or on using an OGL at all. No, you would have, yes, you would lose all exclusive right immediately. I would not accept that. If that's included in this permanent license, if this is included in the license, then for clarity, nothing contained in this section impacts your agreement that are licensed content, unlicensed content, and anything else you are not otherwise expressly authorized to use under the terms of this agreement, or any agreement remains our sole property. I mean, this is fine. It's this right here. Particularly this statement right here. And the fact that those three words go together, the court usually doesn't like. Courts really, really don't seem to like combining perpetual, irrevocable, and royalty-free. Courts don't like that. They usually see that as a as not really being a license. And they usually don't like that. and in fact are usually, those are penalties imposed by a court during an antitrust breakup. It's not even an interactive theft, it's just the court doesn't like those terms combined, right? Like, if it's irrevocable and royalty free, it should include an expiration license date. If it's perpetual and royalty free, then it can't be irrevocable. Like, you can maybe get away with perpetual and royalty free if it's non-exclusive, right? Like, that does include the term non-exclusive. So you might be okay. You might include the perpetual and royalty. You could use the perpetual and royalty free there. But the minute it becomes irrevocable, the court is like, then there's no. The courts usually, again, I'm prefacing this with a usually, would say that is not a balanced agreement, right? Remember we talked about, like, the exchange is, it could be unconscionable, but it also is like there isn't any, where's the bargain, where's the benefit to you? There really isn't one in this moment. No, it would be legal, but it's one of those that would probably get thrown out. Like, and I guarantee you it's a severable clause. Meaning the court could throw out that particular clause and not throw out the license itself. We're providing the permitted content as is and make no representation or warranty of any kind of concerning your use of the permitted content except as... Okay, yeah, this is pretty standard. Yeah, I have some serious concerns about this whole document. We have no liability to you for any types of damages in connection with your use of the licensed content, including without limitation of any indirect, consequential, special, punitive, or exemplary damages, so long as our content at issue is not grossly negligent or intentional. Okay. This is very strange to see in a document like this, where the IP is at issue, and it's a copyright or maybe even a combined copyright trademark. I mean, that's usually tied to, like, patent and production of things. Yeah, and this statement right here is like, we can't be grossly negligent, but our lawyers say we need to include the last clause under Washington law, so it goes in. Yes. It's both grossly negligent and intentional. Grossly negligent is a standard for a particular thing, and it must be included because you're creating a contract under Washington law. Hi. Any notices you send to us must be sent to us via... Okay, so it's telling you how you have to communicate. We may send any notices to you to any email or physical address we can locate for you, including the email address used for your registration with D&D Beyond if you required a registered account on that platform. Okay. This is about notice. It's about how they're accepting notice. Although most courts will say you can specify what form of notice you would like, or communication you would like, but a court usually will say if those forms of communication are not responded and there's other forms of notice you could apply, it will accept other forms of notice. But it usually requires you to have exhausted this one first. This agreement governs your use of the licensed content, and unless otherwise stated in this agreement, any prior agreements between us and you are... Exactly. Okay, here you go. This immediately gets rid of the original OGL. You're relying only on the terms of this agreement and the advice of your counsel, if any. You have not relied on anything that is not expressly part of this agreement. i.e., you didn't look at the original OGL, you didn't consider any other documents, you didn't consider any other FRQs, interviews with Ryan Dancy, or anything like that when you considered agreeing to use the OGL. And you're swearing to it that that was all you were using. If necessary, we can update or amend, exactly like Section 9 in the original OGL. We'll provide notice of those updates. Okay, that's important. You have the right to either proceed under the terms of the updated and amended agreement or follow the provisions for its termination. If we fail to exercise any right we have under this agreement, that failure will not prevent... Okay, so this is arguing about waiver of rights. Also pretty standard. It's pretty annoying, but pretty standard. If we screw up and don't do the thing the right way, that's not counting as waiver. Okay, can't transfer the rights. Fine. Oh, look, there's your severability clause. That's going to be real important, because if the court says, hi, this, you can't keep, you can't do this. This has to go away. Everything else in the document survives. Okay, this is pretty standard, actually, the governing law, and this is all part of a general TOS, right? You will tell, a general TOS will say, hi, you will be abide by the, we'll have what is called a forum selection, or a form of law selection. If we have to go into law, if we go into a lawsuit, we will be bound by the state X. In this case, they're saying the state of Washington, which is interesting. And any disputes arising out of or relating to this agreement will be resolved solely and exclusively through individual litigation. Interesting. It's a class action waiver. But they're not requiring arbitration. Your consent to this exclusive jurisdiction and venue of the federal and state courts located in King County, Washington, for the resolution of any dispute arising out of or relating to this agreement. Hey, that's great, but I can still move to have it transferred. I might agree. See, the thing about the forum selection laws is that they're very interesting in how they're applied. And you can still move to have a case removed to any particular court for a reason, if they're standing to do so. Now, you probably won't succeed, but you can. Basically, this is saying don't try we waive the right to a jury trial. Okay. Okay. You can't, but well, you can, but it gets fuzzy. This whole document I'm not a fan of. I would not accept this statement either. Okay, so now we're into the license, the commercial way. The same, your content definitions, what's covered is the same. Exactly what what you're allowed to create is the same. The licensed versus unlicensed work is the same. The right of ownership, acknowledging that the act of using the license means you're acknowledging that they have the right to license the work, which means you acknowledge that they own the work. It's kind of odd to force. It's really weird and awkward that this is being forced in a agreement that you can't negotiate anything about, but it's not uncommon or even like it's the standard rule for the law of the land is basically like if you have a patent or a licensed thing, the person who takes the license from you, by agreeing to the license, can't come back and during the term of the license then say, well, I don't think you have the right of ownership, because by taking the license, you're acknowledging that they have the right of ownership. Okay, so the same identification of the content, citing the page in the SRD, fine. Okay, here we go. Leveling up under this agreement. This agreement covers all commercial uses, whether they are profitable or not. Note that if you appear to have achieved great success that is consistently meeting or exceeding the expert tier qualification below from producing OGL commercial content, we may reach out to you for a more custom and mutually beneficial licensing agreement. There we go. This is, hi Paizo, we're really annoyed that you're making money off of our content and continually do so without giving us any royalties. So we're gonna contact you and basically force you to agree and strongly encourage that you accept a private license with us and not use the OGL. So okay, we know what they want out of this whole thing now. If you have registered at least one licensed work and haven't generated $50,000 or more in total gross revenue from OGL commercial products in a given year, you are in the initiate tier. All right. Intermediate tier is anything from 50,000 to 750,000. And expert is above 750,000. We're trying to minimize the burden on our creators as much as possible, as you will see below. If you're in the initiate tier, all we need from you is some basic information. Reporting, royalties, okay. And again, encouraging for the custom license. This is all about encouraging for a custom license. Registration. No matter what tier you are in or how much money you believe your product will make, you must register with us any new licensed work you intend to offer for sale by going to the link, filling out the form there, and including a description of licensed work. You'll also take your contact information on where you intend to publish the licensed work, and its price, among other things. Okay, so you have to register the licensed work before you produce it, but that's really awkward because until it's offered for sale, it's not actually subject to, until it's made public, it's not actually subject to the license. So that's awkward. That's awkward. As soon as you make 50,000 gross revenue for a particular year, for year, on products covered by the OGL. Okay, so it's not 50,000 in your actual business model, which is great because some of us don't make any money. Did I mention that I have merch now? And as it is used in this agreement, revenue means any income you make from selling a work licensed under this agreement, or from crowdfunding those works, or any other source of income. Oh. This is a problem. This is a problem. Because this, or any other income source tied to the licensed work, now you're looking at your Ko-Fi, your Patreon, your Twitch subscriptions, your YouTube subscriptions. This is now a problem. And you reach the intermediate tier, you'll need to method of reporting income. In addition, you'll need to provide us with your year-end numbers by February 15th of the next year. If and only if you are generating a significant amount of money, over $750,000 per year across all licensed works. Yeah, they're going after a bunch of the mid-tier too. Because I bet Kobold, you know, Kobold makes a bit of money. Kobold has their streaming channel and what they do with Dot, and, you know, their YouTube. The revenue you make from your licensed works in excess... Okay, so the revenue has to be from the licensed works in excess of $750,000 in a single calendar year is considered qualifying revenue, and you're responsible for paying us 20 to 25% of the qualifying revenue as explained in Section 9B2. We'll go immediately to that. We'll go back to that. Though this agreement is effective January... Okay, but this agreement is not going to be effective because we know that this is not a published document yet. We want our community a lot of lead time. Okay, so they're giving you until January 1st, 2024. All right. It's not horrible. So yeah, Dragonicore, what this is saying is... No, it's okay. I'll go back to it explaining. As soon as you make $50,000 in gross revenue for a particular year on products covered by the OGL commercial, as it is used in this agreement, revenue means any income you make from selling a work licensed under this agreement, or from crowdfunding those works, or any other income source. It's this. The any other income source that immediately becomes a problem. Because again, it's still going to be an issue for... it's still mostly about print and PDF documents, which is what the OGL covers. But now it's looking at who they're going to start charging royalties to, or how much you need to... when you need to start reporting that you make the money, is about your income value. And that is where things get fuzzy. Basically, they want to know how much money you're making from their product, which is fine and valid. And usually included, they can ask about your revenue of... But here's the thing. Legally, they can... And again, caveat of it depends... They can ask about your revenue that you make from their product. And they can ask about how much you intend to sell. Although the price that you intend to offer for that product, that one gets fuzzy because usually that is protected because that would be your business decision. And is it only where it's covered by the OGL or overall? That's the point. This is now, or any other income source. So like the previous statement of, means any income you make from selling a work licensed under this agreement, which is the same thing as the OGL, so anything you created using the OGL, or from crowdfunding those sources. Okay, now we're getting into how much money are you making on Kickstarter for your setting book like Sina Una. Fine. Or any other income source. That's not defined well enough, and I have serious concerns about it. I have concerns about this. The fact that there is a delayed collection, okay, that makes sense. It's a thing. It exists. Yeah, but that's the thing, is like it has to be tied. I would assume it would have the day job that covers the bills. That's the question, and I don't know. Like, it has to, I would assume, based on the previous statement, it would have, and that's why I go back to, this has to be a draft, because no lawyer is going to be that vague. But it also is, this is an FRQ, and not 100% the actual final document, although it's written as the final document. So I have concerns. At the initiate and intermediate tiers, you pay 0% royalty. At the expert tier, you'll pay royalties as follows. If your licensed work is crowdfunded or sold via any platform other than Kickstarter, you will pay 25% royalty on the qualifying revenue. If your licensed work is crowdfunded on Kickstarter, our preferred crowdfunding platform, you will only pay... Oh, there you go. This is the force you onto their platform concern. So now you're paying 20% of your Kickstarter money, and Kickstarter takes a higher percentage than something like Indiegogo. Dragonicore, do you have Kickstarter's statement? Let's see if we can't find it. It's not being forced to opt into. You just are forced to take into. Okay, so John wrote a... Okay, so basically what they're saying is, oh, well, we tried to get involved, and decided we were going to negotiate a better deal for them. I don't know how much I buy that. I don't know how much I buy that. Yeah, it's going to be on top of whatever it has to be, and because it's gross, not net, it has to be on top of whatever Kickstarter is going to take. If you have more than one licensed work and only some of your licensed works are funded through Kickstarter, you will pay royalties on your qualifying revenue based on a proportion of your total revenue that was earned through Kickstarter. For example, if you sell 2 licensed work and one of which earned $600,000 on Kickstarter and the other which earned $200,000 off Kickstarter, you'll have $800,000 of total revenue and $50,000 of qualifying revenue, of which 75% came from 25% not. So you'll pay royalty of 20% on 300. Wow. Wow. Those are not small numbers. But at the same time, you're looking at $750,000. So I was right. The 20 and 25% is anything that's above the 750,000. In which case, it's still not great, but it's not as bad as I thought. You're not paying the 20 or 25% on anything $750,000 or below. It's only the amount that is above, the gross amount above that 750,000, but it's still gross and not net. It's still gross and not net. Oh, and they're reserving the right to charge interest at 1.5% per month. Whichever is a little lower. Okay. Any unpaid royalty. Okay, so yes. So this is the, you have to pay your royalties on time and pay the full amount. If you're charging royalties, including this statement isn't bad. It's just like, yeah, so Jer, so at $750,004, you pay $1. And that's assuming that you made all of that extra dollar not on Kickstarter. Because if it was made on Kickstarter, then that $1 is going to only, you're that $4, you're only going to pay 20% on, not 25. You must complete accurate records, including calculations of the amount due for a period of 3 years, which is the royalty period. Okay, this is actually not uncommon, and if you are a company, hi, this is where I be a little bit pedantic. If you are a company, and anybody who's making, you know, significant money selling things, you are now a company. You should already be keeping this track, and this is litigation proof. And there's an entire subset about backup tapes and how long you keep data. And usually that's a thing that you should do. And since the IRS already... This is a non-issue because it says 3 years after the royalty period. The IRS usually requires that you keep it for 7. So that should be a non-issue. They have to ask for your records. Yeah, okay, this is not horrible, but it's not great, and still within the bounds of normal business practice. Fundraising. We don't object to you crowdfunding your licensed work, but we need to address concerns about overreaching and prevent the funding of infringing products. Is that this section is very specific and require you may you may crowdfund okay, this is assuming you're crowdfunding things that were attached to their licensed work, and if you're crowdfunding something that's not none of their business, you may only crowdfund the production of the licensed work. Oh fuck. Oh, hell. That's going to be a problem. Look at this wording again. The production of the licensed work. It does not include any profit in the crowdfunding. No infringing materials are given out as perks or rewards. Yeah. The primary product of your campaign must be a licensed work, such as a campaign setting. You may have stretch goals that are not licensed work, provided they do not infringe upon our intellectual property. For example, a dice set that your company's original logo, but not one that with ours is permissible. You may also have stretch goals that would otherwise qualify as licensed works, such as modules and adventures. Those additional modules and adventures do not have to be registered separately with us unless and until you decide to sell them separately from the campaign. Okay. Your entire campaign, including stretch goals, is considered one product for the purposes of royalty threshold. If your campaign raises $750,001 or more, you pay royalties on that last dollar because the product you are crowdfunding exceeds $750,000 threshold. That said, revenue for any add-on material that backers separately purchase is not considered qualifying revenue unless the add-on is also a licensed work. Bruno Battle Axe, author of Throwing Blades, a 5e sourcebook, and Blocking Blades, a 5e campaign, made a lot of money out of most publications last year. Given how well Throwing Blades did, Bruno decided to crowdfund Blades 2, Electric Boogaloo. He includes miniature replica blades as a stretch goal and has a backer tier that grants access to all stretch goals. Replica blades are not licensed work because they are not text printed or printable. There you go. But all revenue from the backer tier still counts as qualifying revenue. But makes them available as add-ons for separate purchase because the miniatures are not licensed and they're being separate. Okay. That would be, but unstable Dios, you would still have to pay that subsequent 1.3 million private investment, because it's a private investment in which would count as revenue towards the investment is not the same thing as revenue. So that, oh yeah, it's like make your math easier, but it's make your math easier in a way that basically gives them more money. You will not state, suggest, or imply that your licensed work are endorsed or associated with this, except that you must apply a creator badge to indicate your licensed work is in compliant with the agreement. Okay. This is the same. This, although very vague, you will not do anything that will harm our reputation, is part of most standard licensing agreements. You know, it is what it is. It's vague, but it's usually requires a lot of active work to intentionally harm for that to be invoked. If the other items aren't included in the tier and they're separate, didn't it say it didn't well, that's the thing, is like, if the product is not a licensed work, i.e. it contains no licensed material from Wizards of the Coast, then it's not, and it's a separate individual tier or stretch goal, right? Or then it is, so if there is a tier that includes all stretch goal, okay, so how is this phrased? Bruno runs a small campaign, includes some miniatures, but makes them available as add-ons for separate purchase. Because they're add-ons and they're not part of a stretch goal or a donation tier, then they don't count as revenue. But the minute they're a donation tier or a stretch goal, yeah, you can't do it as an all-in-one. You have to hope people are willing to do things as individuals and pay it out that way, because otherwise the math is really hard for you. The same termination agreement. The reasons for termination are the same. This PR statement BS is the same thing upon termination, and then the indemnity. All right. Any changes here? Nope. Again, I have serious problem with that B. Like, I honestly cannot see how that would stand up in court. Unstable Dios. But according to their rules, if it's a stretch goal, if it's part of the, because the miniatures are a stretch goal, and with a backer kit tier, basically what it's saying is the miniatures are a stretch goal, and because you have a backer tier which includes all of the stretch goals, it now counts as qualified revenue. Yeah, that's the thing, Jer. I'm reading through this, and like there are parts of this where it's like, this document was not written by a lawyer. This document, I can tell you right now, was not written by a lawyer. Parts of it and phrasing is very obviously taken from lawyers, but this document reads like the FRQ and not the actual. This is what I'm saying, is like, I've said this before, I don't believe this is, even as a leak or a non-final draft, this was ever intended as a legal document. This was intended as an explanation put up on the website and let people read it. Because there's so much here that lawyers like to push the envelope and like to see what they can get away with, but the minute anybody challenges them on them, you know, a bunch of this is not going to be valid. Lawyers can also make suggestions, and for some, you know, various reasons, their clients can ignore them. It's almost like that's a thing that happens pretty frequently. Yeah, why did it do the thing? Come back. Come back. OBS, stop being bad. Sorry, I don't know why why that happened. OBS was being weird. I guess OBS and Stream Deck didn't like each other for a second. Yeah, it was written by a CEO who wanted something, and then... Yeah, it's like, this is... And there are pieces in here that, again... Like I said, this question about indemnification, right? All of this indemnification conversation reads like it was taken out of an insurance policy. And, usually indemnification is policy terms in a, usually if there's an indemnification policy terms in a licensing agreement, it's basically, we reserve the right to join. It's C, right? Like, we may at our discretion seek to intervene in a case brought against you in order to join in the defense of the claims. Basically in the sense of, like, I'm watching, going back to our beer analogy, right? Like, I created this beer pump, this beer filler machine, and Coors is being sued because, you know, there was a massive accident and it broke or something. And I see that they're doing, you know, I feel that I need to act in defense because possibly, I need to join the case because possibly Coors is going to claim, well, no, it was a product error and not user error, or, you know, it was a design flaw. I need to be in part of the case to protect my interests. I can't think of a way in which, you know, I cannot think of a way legitimately in this, what is being licensed and how it works would cause you to have a claim that, you know, would have a claim against Wizards that wouldn't be an inherent you were brought in early point. It's like, this reads, it legitimately reads like a draft that was assembled from pieces of other people's publicly available, like, they took things from the OGL, they took concepts of what they wanted to say and what they wanted it to cover, and given the fact that it had a date of January 13th, and you didn't see anything about this released on January 1st, this document is not the final draft, by any means. Like, the rest of this is all the same. Notice is the same. Any prior agreements between us and you are no longer enforced. That brings back to the previous documents of the OGL. Updates and amendments is the same thing. No waiver of rights. Assignment, fine. Severability, fine. Review by counsel. Yes! Have your counsel redeem this. Okay, so we've learned a few things from this document. As it stands right now, this reads like a document. Did they have a year attached to it? I mean, no. See, the thing, Jer, is that this is supposed to be, was the dates about effective dates that were in this are January 13th, 2023, with the first date of payment for royalties being scaled to January 1st, 2024. So they're this document, given the fact that there hasn't been released in any way, shape, or yeah, the royalty family. I think that the fact that the date is the 13th, which is literally in 3 days from now, and they have not actually officially released this document, and therefore have no ability to consult, people don't have ability to consult with attorneys about this, and there's no way you could just hand this off to people as an NDA, right? Like, this document is an open license, can't be protected under NDA. I have a lot of concerns about this document. And if even a bunch of these provisions end up in the final, my recommendation to people would be don't do it. Just don't do it. And that this document is legitimately designed to encourage or force private licenses and to force certain companies to be off the OGL. But on that wonderful note, thanks for hanging out, everybody. Thanks for chilling with me, how we, feeling pretty good and reading through this. If this is the official final again, caveat, this is not a final document. This is not the final terms. This is a leaked document, so I have no ability to verify its validity and its provenance. What is the point of the intermediate tier? The royalty is still $0. So that goes back to the point about policing your license, right? If you are a licensor, that means you're selling a license, you're offering a license to somebody. You're responsible for policing your license. Otherwise, you might end up in the case of what we're calling naked licensing, where if you don't know who is licensing it, or you don't know who the licensees are, you don't know what they're doing with the product, you cannot then police your license, and the government the courts would basically say, I don't see you actually actively working to keep your license valid. I don't know why you should benefit from the protections of copyright or trademark. That's why the intermediate tier exists, because they're not going to charge a royalty, but they still need to be able to claim that they know where their license is being done, and that they are reacting to when people use their licensed product in ways that they don't agree with. Dragonicor says, you're stressing in a game on the 14th. Are you releasing a game on the 14th? Are you publishing a game on the 14th? Or are you streaming in a game on the 14th? Because again, the OGL doesn't apply to any stream or APs. Yeah, so the intermediate, the two bottom tiers there are basically there for Wizards of the Coast to say, here, we know what people are doing with our product. And above the intermediate tier is basically, and we know how much money people are making from our product, so we know what value our, you know, live play, but that last bit that got vague was me mildly worried, as we don't want to give them rights to our DM's homebrew campaign stuff. You wouldn't. Unless, so that's the thing, Dragonicore. The stream itself does not allow for the for them to get rights. You have to publish the homebrew somewhere. You have to put it into a PDF, or put it on the DMs, or put it you have to put it as a document somewhere. Just playing the game would not grant them those rights. Not even under this document. If you published, if your GM decided, I like that campaign, I really, really like this campaign setting, I think it would make money, I think other people would enjoy it, I'm going to put it out there. Or even if you put it out there for free, that's when they're going to start making money off of you. Or possibly claiming it as their own. Well, excuse me, not claiming it as their own, claiming it as a perpetual license. Yeah, so then, Draconicore, I think the thing is, you go ahead and play, but don't publish anything. Or if you do publish it as a setting, publish it as system agnostic. Right? Unless, that's the thing about the OGL. Unless you are using licensed content from D&D, the OGL doesn't apply to you. If you just create a setting... Yes. Yes. So, it doesn't matter. So here's the thing. This is the argument, and again, I'm going to use the "it depends" because lawyers speak. If this book is published and set for sale and entered into the marketplace as system agnostic, then it doesn't matter which system you yourself chose to play it on. And if you don't publish anything that includes licensed content from Wizards of the Coast, they can't touch it because it doesn't belong to them. Yeah, so again, as of right now, having read through this document, I will officially say I myself am not going to publish any additional items on either the DM's Guild or using the OGL. I am so happy I could help you, Dragonicore. I think that is the most important thing, is that there are a lot of people out there talking about things and being very panicked. And one of the and although I am not yet a lawyer, my caveat from earlier, although I am not yet a lawyer, I am still bound by certain standards of responsibility. And one of those standards of responsibility is to provide information. Now, none of you are my clients. This is not legal advice. Hashtag not legal advice. You are... But it is a responsibility of a lawyer to provide as much objective information as possible so a client may make an informed decision. While at the same time also recognizing that maybe the client doesn't need every piece of information that you know. Like, I'm sorry, there's a bunch of things I didn't say because it has to do with the more complexities of the legal thing, the law, and how that would work. But based on the way things are looking, and again, my 3 caveats, this is not a final document. This is obviously not the final document. It's a leaked document, so I can't prove its provenance, and things might change. So, but for my own self, I am not going to be publishing anything additional on the DMs Guild, which has its own rules, which are separate from the OGL, or using the OGL. Exactly, Hawkeye. It's just like med counseling. Teach the patient what they need to know, not everything I know. Unstable CEO says, I still think a good alternative would be to create from ground up a D&D alternative which still use the same mechanics and also builds out a set of compatible stat blocks. I mean, go right ahead. Go and do it. You can. It's all mechanics, and that is not subject to copyright. And to answer your question, Hawkeye, yes, if you are publishing things on the publishing on DriveThruRPG, use the OGL. The advantage to publishing on the DMs Guild allows you to publish in settings that are already published, already established, and people know about. So, again, this is my calm way of explaining things, and hopefully I was able to provide enough information for you guys to make an informed decision. When we see the final version of the OGL, whatever that form takes, I will do another one of these looking at the final version. But I think that's it for tonight. I am gonna go ahead and sign off. I have been your friendly neighborhood Prax. Thank you for being here. Thank you for hanging out with me tonight. I hope this was informative. This will be going up on YouTube. I'll also be doing some little edits to cut out a couple pieces, basically just the break, condense the break, and a couple of the raid responses just to make it easier. Hey, PB! Just as we're getting ready to wrap up. And no one else is up. That's a problem at 2 o'clock in the morning. So that's the thing, Hawkeye. Your homebrew locations are all would be yourself. You can do whatever you want. The map is yours. You can do whatever you want. WotC, the classes could be argued. Some of them are generic. Oh, glad you could work. Welcome for all lurkers are always welcome. The classes might be some of the classes might be argued generic. Rogue, fighter, cleric, wizard. Those are generic. Bard is generic. But the subclasses are not. And what ties into specifically, yeah, we can talk about it later off screen. We can talk about it more. I'm happy to answer questions. We'll probably do another one of these. So again, it's about what is considered generic, what is considered that they actually own, mechanics are not copyrightable, and, I'm glad people found it informative and enjoyable. We are ramping back up and seasons are starting back up. And if you don't know, hi, I also stream actual TTRPGs. We have 2 long-running campaigns running right now on the channel. A Song of Agapia's Fortune, which happens to be a high-level D&D 5e campaign. Players started at player level 14, and things got very interesting at the end of last season. A wedding is planned. Also, possibly, things were discovered about people or things that should not be where they are, but they are, and you might find out. But we're starting that back up soon. Next week. Next week. Insert GM panic here. You can catch all the VODs for The Song of Agapia's Fortune on my YouTube. We also are starting on Sunday, Season 5. It's 5. There we go. Season 5. final countdown of the final season of Witcher Roads Home. It is our Witcher TTR Golden Age of Witcher. The end of last season had some very interesting things happen. Some revelations happened. People may have had the Lord Math experience, which, if you can't, if you can, there's a, in my videos, there's actually, can I just pull it up? I think I can. Let me pull it up. Oh, here. There is a highlight of the Lord Math experience. Because the Lord Math experience is a thing. And that is indeed a thing that must be shared. And you can check out the Lord Math experience right there. Trademark description. I mean, technically it's copyrighted because it's in print and I created it. Therefore, it is copyright. Trademark, it does not have a trademark protection at the moment. That would probably be Trooper's trademark protection and not my own. But you can check out that, or you can check out the VODs of all 5 seasons. I will warn you that they run a little long because I am more than happy to sit back and let my players RP, and I have wonderful, fabulous players who get to tell wonderful, fabulous stories, and I may let them go a little longer than you should because they're great. But we're starting the final season of that. I'll probably do a couple little more pop-up streams like this. Maybe some video game streams, depending on my schedule. And my schedule will be very erratic until I figure out my get used to classes next week. Final semester, y'all. And next Monday over on Wandering DM, we will have the season premiere of season 2 of Montreal by Night, our Vampire 5e campaign. And, there's a surprise. I can't say anything, but I saw some of the surprise, and I can't wait. I can't wait for you all to see it. Also, hi. You may have noticed there's a new button below me. It's a thing. I added some merch referencing, some of the stuff that we do on the channel. You can get some Which Yonto are you again? When in doubt, blame Iago. Or the Mechton's cruise. We are here to make interesting choices. There's some interesting merch up there. You can check it out. I tried to make everything priced in a way that still is affordable to people. Yeah. Catch all of that. And, we'll see you next time, everybody. Bye. Oh, yeah. And you can find me at Deirdre on Twitter or at Prax the Bard on Hive. I talk about TTRPGs and law and classics and anything that comes into my brain. And I really appreciate each and every one of you hanging out. Until next time, everybody.